For some administrative reasons.
Maybe pardon to mention. I'm a government of India undertaking
Give the memo. All matters will be there.
Last date for submission of bill is 26th and 27th.
Give that.
One matter, madam, this is only listed, madam.
Give.
My knowledge is to mention that matter, madam, this is the conflict matter, madam, compliance matter, that is on this date of tomorrow, madam.
Let us see. Whatever, give.
I'm just from revision, I'm just bothering my law. Last day, I mentioned about the item 39 about this appointment of G scheduler members. Now what I'm paying my lord, even though it is not listed today, let's see, may modify to the extent one post may be lying because one petition is there. One post may lying,
It is listed today.
No, it is not been.
Why it is not listed? I told.
You are praying for adjournment yesterday.
No, I'm paying, but after tomorrow, Lakshmi said that it will continue, so it can be.
So it was, I directed that the matter would continue thereafter. All the matters.
That's why
Why it is not? Yesterday I instructed. All the matters will be there. He says his matter is not listed. That was item number 39.
Can it, yes. Item
Why it is not here?
Item 49.
Item 49 is not here.
No, it's not here.
Oh, that you must have mentioned
No,
26 June.
Lordship said that on 29 onwards should be taken up. That's why I will not keep mom. Because if you take it tomorrow, I have nothing to say. Can it be after lunch or tomorrow?
No, it is already shown as 26.
That's why I'm filing a memo.
Order
That's
is
why I have
signed.
got tomorrow.
I don't think order is signed. Order is signed.
No, I have signed all the orders.
So I file a memo. Let me for tomorrow.
But it was not taken up yesterday. That is why. So there is no order. No.
Yes.
Partner also said that.
Give the memo.
Tomorrow, ma'am.
No, with due apology, my lord. So my last date for
I
submission.
know, I heard that on the last day is 27, sir.
26, 27, 26.
Yes, let us see.
My lord, my case is so very urgent, my lord, regarding Puri Ratha Yatra, my lord.
What?
Honorable
You want to stop the Puri Ratha
No,
Yatra?
no, pending the
Very
doing,
important
my
means.
lord, court order not carried out of the municipal Puri municipality, my lord. They already doing a quotation called vendor regarding the shop in Bodhanda, my lord.
The whatever.
So, my lord, honorable court already clearly stated that not to do any.
We'll see to it. We'll see to it.
My contact number, my lord.
Right.
Sir, we will see to it, sir. Why you are exhausting your energy in that? Come, matter will be listed, come.
My lord, already today.
Matter will be listed, come.
Item number 3, on behalf of Mr. Dr. J.K. Lenka, kindly be adjourned for 3 weeks because his wife is admitted in the hospital. That's why we have on behalf of Mr. Lenka. Item 3.
Who is for the other side?
With the lordship permission, may I mention item 40 from the list?
Let us start.
As
We may reach to 40. Don't worry.
I just, I've received the counter affidavits only yesterday.
You just remind us when the matter is called on. Don't worry.
Lord, Attorney General may be appearing tomorrow. Can it be fast case?
Let us see, sir.
Oble.
Yes, call the list.
Oble. Item number 1.
May I please, my lord?
Yes.
Yes, my lord. This matter was listed, my lord, out last Friday, my lord. And your lordship.
What? Oh, this was, we were supposed to dictate.
Yes, my lord.
We were supposed to dictate the order.
Half of the order your lordship has dictated. And thereafter.
What is the matter about? Yes, I did not find time because of some.
This is the revival of the lord. Kindly come to page 57. I will clear every annexure, my lord. Where release was granted on 24th December 2003. Annexure 1, my lord. Page 57.
Yes.
Then, my lord, original lessee was died on 9th January. And this fact, my lord, I have informed on 31st March 2005 as page 59, my lord. And thereafter, my lord, there is a death certificate.
What he's saying, I could then.
Oh. Oh.
There is a
Yeah, I got it. Yes, that
Yes, my lord.
reconsider.
yes, my lord.
We have
Thereafter,
already dictated the order. I think in the midst of the dictation, it was pointed out, we were proceeding on the basis that the review is still pending.
pending, my lord. Yes.
But in the midst of the matter, it was pointed out that the review is also disposed of.
Review
Yes, my lord.
Now, it appears to us that the review was disposed of without adverting anything on the materials which he disclosed before the revisionist or reviewist authority.
Yes, my lord.
He's
Please,
supposed to he's supposed to pass a reason for that. That
Yes.
is not done. So we are reverting it to the review authority to reconsider the matter and pass the order in accordance. with-
Review does not lie.
Obliged.
Right, my lord.
Huh?
Review does not.
Mr. Rule 46 proviso.
Talks about the review.
Review petition. So the first, the substantive provision that says about appeal.
Yes, my lord.
Marginal note says about appeal.
The proviso talks about the review.
Review.
Now, what is to be done? If the review is also provided,
For authority also,
Send for reconsideration of the matter that
Correct.
application dated.
give.
Order
That is what is the provision?
Page 122.
What
Rule
is the
56,
provision?
Rule 1.
46.
Rule 46, sub clause 1 proviso, my lord. It is extensive, my lord. It's not like order 46, rule
Rule
1.
46 of?
Rule 46, sub clause 1, Orissa minor.
Orissa minor constitution rule 2016, man.
No, I do not find any proviso to Rule 46.
There is a proviso, my lord. I have quoted on.
I have not.
Your lordship is the
Not
quote
one.
2024, my lord, edition. I
No,
have
this is the
quoted.
2025 edition I have in my hand.
I have quoted on Rule 15, as page 15, my lord, of my petition.
46, Rule 46.
Rule sub clause 1,
It is not here.
page 15, my lord. Your lordship see us page 15. Last day, my lord, I have passed on my book.
substitute. In 2000.
Oh, now it is here.
No, it is
Yes.
older.
But new one, 25 does not have.
I know. That day I got confusion.
It does not have a proviso. It is a 2024. But it is a 2025. That's why I got confused.
Yes.
Which one is correct? The proviso is there or not?
Is there,
Provided,
Is there? Are you sure?
provided that in case of matter related to.
No. I have seen. This is the book of 2024.
Sir, please look to this. This is 25 edition. Mr. Das, please assist.
I have 25 edition. It does not have a proviso.
No, there is no provision, I mean.
I do not know, but 2024 book, it has a proviso.
Mr. Das, can you find out the gazette notification of 2022? That will clarify the position.
No, it is here, printed earlier.
Gazette.
Just notification has to be here.
This is 22.
2022. 22 rules. Now insert. 25.
Appeal provision is where 46 is concerned. Well, appeal provision is there.
No. Amendment Rule 27. Section 4, 33. 42, 58. 51.
So 46, there is no amendment. 46, there is no amendment.
No, your lordship, only substitutions. with it.
No,
Where is the gazette notification? Gazette notification is given in this book. There is no amendment to 46, neither in the amendment rules 22 or 23.
So for 46 concerned, there is appeal lies, my lord.
sir,
Sir,
please look at it. We are not talking about. You are correct. Substantive provision talks about appeal,
Yes.
but there is a proviso appended to sub rule 1.
Provided that in case matter related to specified minor right, state government may review its order on
Correct. So the power of review is also given.
given, but that has been rejected, my lord. Your lordship says
You are,
he has not been.
please,
asked by-
please, probably, let me be very clear on that.
Yes,
Though Rule 46, sub rule 1 talks about the appeal,
yes.
but there is a proviso which is also appended to sub rule 1, which talks about the review, power of review.
Yes, my lord.
So if the proviso also confers power of review, then the authority can review the order.
Yes,
There is
ma'am.
no difficulty. You can't say that 46, the marginal note or the head note is talking about the appeal.
Yes.
So it will be only restricted to appeal. No. You have to look at the context of the order or content of the order.
Yes, ma'am.
But I find there is some confusion because 2025 edition of this
Provision.
rule, I do not find this proviso in 46.1.
46 one.
Look at this.
Yes.
My brother has given you a book. I am also giving. Proviso is not there in sub rule 1.
That is-
amendment ହେଇଛି
that-
2022 ରେ ଏଇ amendment ରେ ଏଇଟା
Yes, ma'am. 22.
ସେ 22 amendment ରେ
Mr. Das, I have verified, checked up. I have downloaded the gazette notifications of 22 amendment, 23 amendment also. There is no amendment carried in rule 46 is concerned.
So whether that proviso is in fact there or not, because we are conscious that the power of review and a remedy of review or a remedy of appeal, both are statutory remedy. Unless the statute provide, they cannot.
Yes, ma'am.
So that is what confusion is. Please dispel the confusion. Whether the proviso is in fact there or not there.
I have to verify.
Their right really arises from the proviso.
Yes, ma'am.
Yeah.
Let me verify from the court, ma'am.
I do not know.
May I clear, my lord? The one thing, my lord, kindly see the proviso. It's related to minor minerals. I am minor minerals, my lord. Decorative stone.
Sir, are you understanding what is passing in our mind?
Yes, my
But
lord.
there are 3 books which are available to us. All 3 books are different. So far as Rule 46 is concerned.
Yes.
Whom to rely? Tell us which book we should rely. You've seen my book?
Yes, ma'am.
No proviso.
No provide.
Now what to do?
22 Raman.
Okay,
That is what we are stuck up.
Either in 22 amendment or 23 amendment. Both gazette notifications I have downloaded. Please see.
It's not there.
I have to verify, madam.
It's not there. That is what we are really. And why this 2024 book, what book they are relying, it contains a proviso. From where it came, how it came, we are unable to comprehend.
Amendment. 22 Rashid. Amendment. That will very well let you come next week.
That is the whole trouble. The book, madam, which you handed over, though contained that proviso inserted by 22 amendment, 22 amendment is at the first portion of the book, where I do not find any amendment having brought in Rule 46. Then how the author of the book got it from where?
I'll see to
It's very risky, sir, because if you rely on a book like this, it's very risky.
Let it come next week, my lord, I'll verify.
Please show us there is any amendment has been done.
Yes, that nothing is wrong. 2016 Gazette notification says about provision.
Huh?
First page
Let it come next week, my lord, we'll verify.
Now my brother has verified from the official notification.
First page
There are two notifications of 2022. One
Sir.
notification.
Sir, 2016 is the original rules, substituting the earlier rules. Entire rules have come at one go. Page 47 of that Gazette notification, which is Odisha Minor Mineral Concession Rules 2016, that speaks about proviso.
Yes.
So how come that book brought out that amendment? Please, forward.
Oh,
Yes,
no, give it to them. I have seen that. That's true. I got it.
You have also not checked up while drafting the petition. You have just
Yesterday, today, that is 27/12/2022. I have seen this amendment of 46, where they have omitted the name of Tahsildar, the name of collector and added.
maybe
Yes. Lordship.
Maybe that Gazette I have sent to you.
But
Please
this is,
see.
Your Lordship, 24th April 2020.
There is no amendment carried in 46. That is what I.
There is no amendment carried in 46, but that contains that notification. It has a proviso.
Correct.
Here proviso is there.
Proviso is there in the original 2016.
Yes, that was there also.
Thereafter, in amendments, which this book shows that 22 amendment has brought out this substitution. There is no substitution in 46, sub rule 1.
Yes, my lord.
So while drafting the petition, you have also not verified.
Lordship, the review petition which was filed before the government, there it was mentioned Rule 46(1) of.
What are we asking for? Are you understanding, or without understanding you are just whatever you have prepared you are talking? You have quoted the provision in the petition itself. Have you verified and checked up whether there was any amendment carried on the date of passing the order? What was the law?
The Adabad Malord in Annex 13 and page 84 in the lapsing order, the state government has given assigned the region already. Yes.
He has produced certain documents which has not been referred to there.
Sir, this review.
While review was taken out, he has produced certain documents. That these documents are very important documents to be considered for their claim. The authority is supposed to deal with those documents.
Sir, have you seen the appeal petition? His appeal petition may be styled as review because of proviso. Proviso speaks about review. You check, you come to page 104.
So we do not validate much on this when it is there.
Come to page number 104. He has given many evidences in his favor. Has it been considered in Annexure 19? That is the question we are asking. Annexure 18 is his petition, maybe styled as a review petition. That doesn't matter. Yes.
So we are saying
regarding Naxalite activities, and two reports, collector report is there.
but he says that even during those periods you have granted, so you can't take that advantage of that. Applied before the collector having consequences upon the decision of the competent authority. Up to this, no problem. Okay. Now you says. Where is the order of review?
The review order below 122 below.
122.
122, man.
Okay. The said application for review was taken up by the authority on 24/12/2024 and rejected the same solely on the ground that it is devoid of merit. In the following, then you quote from paragraph page 122, Annexure 19, the last operative portion. Stop. Our attention is drawn to the application for review filed by the writ petitioner, annexing several documents which would impact the decision taken by the authority at the initial stage. And therefore, it was an ardent duty of the authority, considering an application for review, to return its finding thereupon. The importance of providing a reason in a judicial as well as a quasi-judicial dispensation is imperative to stop. The authorities cannot reject or allow the applications without providing a reason, which is one of the fundamental duties ascribed to a quasi-judicial authority while deciding the claim of the parties. Stop. The reason. Sorry. The reasons are to be provided, which is indispensable, as the litigant has a right to know the grounds on which the claim is negative or is allowed by the authority. Apart from the same, it helps the higher authority to understand the decision-making process and what actually swayed the mind of the adjudicating authority at the time of determining the claim of the person. We find from the said order dated 24/12/2024 passed by the review authority that it is bereft of any reason, despite the fact that the several documents impinging upon the claim, as well as the determination made by the original authority, were disclosed And therefore, it was an ardent duty of the review authority to return its finding thereupon. Full stop. Solely on the ground, next one, solely on the ground that the order dated 24/12/2024 is bereft of reason, the same is hereby caused and set aside. Stop. The matter is remitted to the review authority who passed the impugned order to reconsider the same afresh and dispose of the same within four weeks from the date of the communication of the order on merit. Stop. It goes without saying that this court has no occasion to go into the veracity and the authenticity of the claim made by the writ petitioner. And therefore, none of the findings made herein above shall have any persuasive effect at the time of deciding the said application for review. Stop. It is open to the authority to decide the same independently on the basis of the materials relied upon by the respective parties, and the order shall contain the proper reasons in accordance with law. With these observations, the writ petition is disposed of. No order is to cause.
I'm obliged, Lord. Greatly obliged. I'm deeply obliged.
Up to this, thereafter. Call the next.
Item number 2. Pursuant to the direction of the Honorable Court. We have obtained instruction and we have filing an affidavit. It's only the copy on my left friend. Let him take instruction, my lord. Today we have filed the affidavit, so it has not come on my lord's board. We have e-filed it to go. Lordship may call this matter next week.
Yes, they have filed the counter today.
Just once.
Yesterday, I filed the registry.
And the copy is given in the court.
Subject. That is filed for the today in the registry. I will keep each for more. So, it's all copy. There are one J. Jana.
In open court.
For permission. For permission. The same thing. Administration. It's just not.
1 minute. 1st of July. Item 3. Item 3 was posted to 15th of earlier mentioned.
Yes.
Item 4.
Yes.
Item 5.
Actually, just filed the counter affidavit and we found it today in the morning.
Give a copy.
Same.
Yes.
Item 6.
Item 6, similar matter has been fixed to 24th yesterday. Also, they have not filed counter. Previous order has been passed. Bullet order has been passed. Okay, the lordships have already has order passed, but they have not filed reply.
Yes, what, madam?
And the lordship said yesterday, similar matter has been fixed to 24th.
27th of
24th.
July.
24th.
24th of July. Item 41 also, it's same.
But you
are appearing in
yes,
41.
Yes, ma'am.
When I record one line that 41, the matter is taken up out of turn on the mentioning of the respective councils, and then pass the order 23. 41.
Okay. Because no season as well, 24th July.
Yes, 24th July.
24th July.
Interim order to continue.
Yes.
Item 7.
My lord, this PL is about the premier university of the state, Utkal University. The prayer has been made to appoint a regular vice chancellor under section 6(1) of the Odisha Universities Act 1989. And till the regular vice chancellor is appointed, an in charge vice chancellor should be appointed according to section 6(10) of the Odisha Universities Act 1989. But my lord, kindly peruse. Yeah.
Sir, why are you not? The university, the vice chancellor is a very important force for the purpose of an administration. What are you doing? Why you are not taking steps? Can a university run without a vice chancellor?
Here the Vice Chancellor, in fact, an in charge Vice Chancellor has been appointed by virtue of Annexure 2. And they will go for regular. Your Lordship may kindly say Annexure 2.
Annexure 2.
Yes, my
Annexure
lord.
2.
Yes.
In supersession of the office notification dated so and so.
So this has already been done on 27th May.
Yes. They have appointed a in charge Vice Chancellor and
What?
they will go for regular selection.
But my lord, the in charge vice chancellor has been appointed in gross violation of the act, my lord.
What?
In Odisha Universities Amendment Act 2024 was passed on and came into
What gross violation? Just tell us, what is a gross violation?
violation of section 6(10) of the act.
What 610 says?
Yes, my lord. Section 6(10).
Yes.
I will provide the copies of the gazette notifications.
Please.
6(10) says that if the regular vice chancellor cannot be appointed in accordance with section 6(1) of the act, then the vice chancellor of any public university shall be appointed as in charge vice chancellor. But instead of referring to any act and in gross violation of the provision of the act, section 6(10) of the act,
Yes, yes, sir. That is there. The proviso is very clear. This gentleman whom you appointed is already a vice chancellor of any other university.
Your Lordship will see Annexure 2 is issued by the Office of Chancellor. So,
No.
take instruction.
How the chancellor, even if the chancellor can issue, but the difficulty is you have to follow the statutory provisions.
Yes, I'll have to take instruction.
What
because this is
instructions?
not by
That
the
he has been
state, but by
harping,
the-
he has been harping this, and the proviso is very clear.
The Office of the Chancellor has to answer, my lord. State,
my lord, you kindly contrast Annexure 1 and Annexure 2. In Annexure 1, the chancellor extended the term of the vice chancellor by providing the section subsection of the act. But in Annexure 2, no act, no section has been repeated without mentioning such an arbitrary and illegal order.
So he could continue with the vice chancellors because subsection 8 that gives a power upon the chancellor to extend. Period of 6 months is there.
Earlier it was
But the word is from time to time means that for 6 months he can continue renewing that.
My lord, the term of the regular vice chancellor is extended up to 23rd May 2024. 25, my lord. Then on 27th of May,
Who are you?
my lord,
You are a public spirited
I am
person.
a public spirited person.
Have you started in this university?
I am an alumnus of the university. I am a practicing
Alumni.
advocate of this court, my lord, and I want to seek the honorable court's intervention in upholding the rule of law, my lord. This is the premier university, and the act has been enacted by the legislature of the state.
How can this be done, sir? It's absolutely a clear case. Who is the chancellor of the university?
governor.
The governor.
How can he?
has been allowed by.
So whatever, sir.
But their secretariat has to answer.
So not secretariat, sir. The government is notifying it.
No, my lord. It has
The
been
copy has been forwarded, sir. Copy has been forwarded to the government.
Copy has been forwarded, but this is a notification itself by the Raj Bhavan, if your lordship will.
Correct. So is it not that you will point out to the chancellors that this is what the law is?
I'll have to take instruction on this, and he has not been arrayed as party also.
Yes, added party two. Party,
Principal secretary.
principal secretary,
Can't be.
chancellor usko
Can't be. Cannot be. You being a representative of the state is answerable. There is no separate panel for the governor or the chancellor.
Because this matter.
You are responsible, sir. How can it be done?
But this has come for the first time. Take instruction. How they have appointed.
The petitioner, who is the ex is a student of the university and the member of a alumni, as well as the practicing advocate, has taken out this public interest litigation, flagging the flagrant violation of the provisions contained in Odisha Universities Act 1899 and 1989, as amended from time to time, in appointing the vice chancellor in charge. Full stop. The sum and substance of the instant public interest litigation, running into several pages, is primarily aimed at Annexure 2, that is the notification dated 27/5/2025, issued by the Chancellor of the said university, when a faculty member of the said university is appointed as the vice chancellor in charge for the time being, till the next vice chancellor, till the new vice chancellor, till the post of the vice chancellor is duly filled with. Our attention is drawn to section 6 within bracket 8 of the
Section 6, subsection 10, Mahendra.
either you dictate the order or let us, that is a freedom which the bench enjoys to dictate. Section 6 within bracket 8 of the said act postulates that the chancellors may extend the time of the vice chancellor whose term has expired from time to time, not exceeding 6 months. Stop. Subsection 10 of section 6. No, sorry, the proviso to subsection 10 of section 6 provides that in the event the vacancy in the vice chancellor's post could not be filled up, the chancellor may appoint any of the vice chancellor of a neighboring public university of the state as vice chancellor for a period not exceeding 1 year, or till the joining of the regular vice chancellor, whichever is earlier. Stop. Apparently, the notification dated 27 May 2025 does not indicate that the person who is a professor in biotechnology at Utkal University is a vice chancellor of the neighboring university of the state. And therefore, prima facie we finds that the issue raised herein needs to be determined for all time to come, as there may be a recurring feature, that it may be a recurring feature in respect of the other universities of the state. The council for the state shows is an inability to apprise the court on the above issue, and raise for an accommodation to take appropriate instruction in this regard. So, this matter in the first week of July. Now, in the second week of July, to enable the council for the state to take appropriate steps and instruction, more particularly whether the person appointed as the vice chancellor in charge is competent to act in such capacity in view of section 6 within bracket 10 of the said act.
Has been, that particular proviso, the rule has been substituted subsequently.
Oh.
So my kindly see how it has been substituted.
My lord,
Oh.
that I want to point out.
I'm verifying from.
I have already provided, my lord.
Sir, you gave me that.
Yes,
You gave me that. I relied upon this.
my lord, there are two acts.
No, this is a Odisha Universities Act 1989 you have given.
20, amendment up to 20, my lord. Then next is.
Then why you are giving it to me?
My lord, then there is a provision to amendment of 24, my lord. That I wanted to point out. Only the neighboring university has been.
Any of the vice chancellor of any.
Neighboring has been deleted. And in consultation with the state government has been inserted. The chancellor in consultation with.
So neighboring says vice chancellor of any university within the state. That is what it comes.
Yes.
So neighboring word deleted.
Yes, my lord. Bless.
The word neighboring university, neighboring word deleted.
Okay.
From 8.
Please, Your Lordship. Your Lordship, as per the direction of the Lordships have taken instruction, Your Lordship, the petitioner is willing to give property security, Your Lordship, for the release of the weapon.
Is free from encumbrances.
Yes, Your Lordship. For the document, Your Lordship, within 7 days, we can submit the original.
Brother, pass an interim order to that effect, giving a security of an equal amount subject to the satisfaction of the Registrar General. Yes.
Lordship, the valuation.
Interim order, we have already, so far as the main issues, we will decide it. So that your vehicle is released,
Valuation, Your Lordship, is, not very.
subject to the satisfaction of the Registrar General. You'll have to give a security. Give that particular report that what the property fetches, give a indemnity that it is free from encumbrances. There is no encumbrances not put as a collateral security in it. Everything you have to give. Yes, next.
Item 9.
I'm a worst contractor. I'm a worst contractor. Let me see at the page 20 minutes is my agreement.
Escalation clause you wanted
Yes.
is what?
And they, what they have done,
Yes, what they have said.
Let me see the impugned letter, let's annexure 15 page 332.
Yes.
Because they are not denying my entitlement. What they are saying, as because in the meanwhile, the circular which empowered them to release my money has been quashed by this honorable court, they cannot release money. That I cannot wait for indefinite period. That is what my prayer is. Now,
No, what circular?
Let's say-
Circular relating to what?
relating to price escalation, payment of price escalation. Let me see the circular for a moment. It is at
The price escalation clause was not there in the original contract.
in the original contract, there was a clause that as per the circular in 2012, my escalation be made. As well as there was a calculation formula given, how it will be calculated. Both are there.
No, I understand.
Yes.
This is normally done in every public
Yes, now,
contract.
Milords, what they say, as because the circular is quashed, we will not pay. But the formula is there in the agreement. That agreement has not been quashed. The circular has quashed. That is unilateral. That does not bind me, Milords.
Where is that? Then you'll have to file your pleading.
I will.
You have to file pleading. You have to file a pleading.
Yes, Milord.
Brother, because this is a case of outer. How soon?
2 weeks. I'm only 2 weeks. 2 weeks. I 2 weeks. There's a
After 2 weeks, matter to appear after 3 weeks.
15th of July.
Much.
Item 10.
May I please vote? Yes, Milord, where the respect of tender process, there is specific restricted condition, bidder have to submit the experience of any public work undertaking, Milord. But the bidder they have selected, they have submitted a private experience, I annexed that of page 127, Milord. And the similar clause your lordship, this honorable court, they have, because of the private, Milord, if the permitting the accepting the private experience, then it will be, Milord, not only fair or transparent, but it is regarding the, Milord, genuineness and the public work, the object of the completion of the government work, it can verify from the record, and there will not be, will be fair and transparent. But if the private experience will accept it, Milord, then it will be, Milord, open floodgates the manipulation of the document. So the condition is very clear, Milord. And the similar clause your lordship has this honorable court earlier, Milord, issue was raised. And this honorable court was the acceptance, your lordship. Your lordship, kindly see the clause, your lordship, page 21. Annexure on 1 page 21, your lordship. Your lordship, page 21. Clause number I, Roman I.
Clause?
Clause 1, your lordship.
Yes.
Since it's a special nature of work, criteria have been fixed as follows. Bidders should have successfully completed at least one similar project of aquarium in any government.
What about the undertaking organizations?
In any similar project of aquarium in any government, state, central government, undertaking organization, copy of completion certificate work order to be enclosed, your lordship. Same has been repeated also, your lordship, page 23, Lord. Same clause has been repeated because page 23, clause 1, your lordship. Superintending engineer, Mahanadi, South Division, Cuttack,
Yes.
come member secretary, Odisha State
Yes, sir. What do you have to say? If you have put the conditions, how can you accept the private contracts?
Kindly have a glance to page 125.
It's what it says?
Well, this opposite party number 4 has submitted the list of the works he has already done.
Please show us that those certificates relates to any state government, central government, or a government undertaking.
Ma'am.
Show us. That's all.
Yes, ma'am.
Show us one document.
Yes, sir.
Which page?
My lord has annexed one document at page 100.
Please, you show us the other documents that, yes, he has. Show us that he has submitted that document.
But then I have to take instruction whether complete document has been filed or not. Because
Take instruction.
28,
Take instruction. He may be selective, no doubt about it, for the purpose of this.
Then I have to.
Take instruction and give. To take instructions after 2 weeks.
In the meantime,
No, there is nothing. If we find that you are selective, then we will impose a use cost on you.
That's my only case that he has not.
No, please, you have not understood what I want to say. He says that we do not know whether it is a complete document of the successful bidder you have included. It may be that he has also submitted a document in relation to the completion of the work in a garment or a semi-garment or such and such. If we find that you have been selective and purposely, motivatedly did not include those documents,
Yes.
face the consequences. Face the consequences.
Petitioner on affidavit stated that all document downloaded and file affidavit. I shown affidavit. That's my only case. He has all documents are in his.
Like 2 weeks time.
Then we are passing an interim order, so you can't give the work order. Can't. If he is otherwise ineligible on the face of the terms and conditions of the bid, can't issue a work order. Can't issue.
And I pray that may grant me 1 week time because I will have to take instructions from court.
Whatever, then either you come tomorrow with the instruction or we will pass an interview. If it is the Cuttack, it is not far off. Arm length distance, you'll have to take instruction today.
26.
Tomorrow. Tomorrow, you just call him one time. Yes, tomorrow. As a first matter.
Yes.
Just remind us that this is.
Yes. Right.
Okay.
You also be sure. Yes,
If we find,
yes,
will not spare.
yes.
Item 11.
You know, which date one are discussing on this case?
Instructions as
No.
8th
of July. 8 July.
Well, if minor police officer not produced before the honorable court, the rescuer cannot be rescued. The victim cannot be rescued.
That's the last resort. We will take care of that.
8th of July. 2 weeks after.
The petitioner is a registered person having its in respect of state is Harsura in Orissa, district of Kundargarh. It is registered place of business is at Harsura in the state of in the district of Sundargarh. It has also registered place of business in Uttar Pradesh and also in Tamil Nadu. What has happened? For the purpose of a requirement of claim in other place of business or execution of work, what he has done, he has transported claim from Jharsuguda, one consignment to Uttar Pradesh and other place to Madras. Claim cannot be moved in one, it has to be taken in knockdown condition. For semi-knockdown, also that is provision under the GST Act, the manner how to carry mirrors. Because what has happened, one consignment of claim mirrors that was transported to Uttar Pradesh mirrors in 6 waybills. Mirrors value of invoice is 1 mirrors. So for a tax implication concerned, I am liable to pay IGST mirrors. Now in 6 consignments, claims are transported knockdown condition. to Miras destination in UP Miras. Similarly, in 9 consignments Miras, in knockdown form of the crane Miras, it was transported to Miras, Madras, and the value Tamil Nadu, and the value is 4.20 crores Miras. So what I am liable on the GST law to pay to the government is Miras, 4 crore 20 and 1 crore 17. But what happens Miras, for transporting Miras in the way bill, I have to mention the Miras invoice amount. This invoice amount of 1 crore 17 Miras finds place in 6 numbers of way bills. Crane is 1.
So they have treated all the 6 independent.
6 times are the invoice. Similarly, 4.2, 420, 4.20 crores, 9 times. But what has happened? But after producing documents, I explained, I have filed explanation or replies there. They accepted so far as 9 consignments in respect of which 4.2 crores, 20 crores of crane was shifted to other places. That was accepted. I produced all documents. They now say, so far as your 1.17 crore is concerned, covering 6 vehicles, plus even though here details are mentioned here, but that was not allowed, and because put to levy of tax after your
Go for an appeal. Good case of an appeal.
That's what is happening here, Viras. But things doesn't stop here. Period is 2018-19, my lord. So 18-19, Viras. And your Lordship knows, because that cannot be Viras. 74, section 74 is a provision which stipulates for statutory conditions. Unless those are conditions satisfied, here they have invoked 2 simultaneously.
Good ground for an appeal.
There's 2 proceedings, 73, 74 Minas.
So
similar situation, my lords have interfered. Many other repetitions also there, Minas. My lords have, because you can't have option Minas to invoke both. What they have done, I am just pressing from the index portion. I am not taking your lordship much Minas ahead, Minas. And you see the index portion. What has happened? The lordship will see serial number 2, SCN dated 7921. 7921, annexure 2, that is under 74(1) of the CGST Act, OGST Act. Reply was filed on 9/10/24. Again, your lordship will find annexure 5, SCN dated 11/5/23. This is another SCN for the same period under section 73. And while the 74 procedure kept pending, now they have proceeded to complete 73 minutes. What is happening? You have to kindly keep in mind, consequence of 74 is huge, because it prejudices, unlike 73, because all the information are there when you passed adjudication order in respect of 73 proceeding. So instead of incorporating those in 73, you cannot keep 74 proceeding pending, and after culminating it an order in 73, again you will switch over and pass another order in 74. This is one. So much legal issue is concerned with us. Because this cannot be simultaneous in 73 and 74. Whereas when proceeding is still pending and you have all information with you, and for want of any willful misstatement, what willful misstatement?
Everything is appreciated, but you are avoiding the answer to the question.
Your lordship proposing appeal. So your lordship kindly think of where I stand. When my liability 1.5 lakh disclosed, I am paying Miras. And can one multiply 9 times, 7 times and ask me to pay? And
I understand this is a good ground, because in one case if they have accepted, in another why they cannot accept.
Here Miras appeal time is also over.
Exactly. And that is what cannot be.
I was there. What do you think? Why thrice I did it? Because I expected this answer to come, because I know it.
So that is your lordship always view that Supreme Court says nobody can be remediless. So that is why I am before asking.
So recent, I was discussing also Rajkumar Banerjee in NCLT. Supreme Court history, even one day.
Yes, that is there.
Outer limit.
There is no quarrel because across the country, all high courts in one go.
What the statutory remedy did not provide, can we interfere?
Seeing enterprise, Hongo enterprise.
Can this be the law?
Hongo is
Can this be the law?
Your lordship can be what I find. Vasudev's judgment is there. I will check on that if that is so, but I
That is
feel
NCLT.
nobody will go
I
empty
just-
handed from
Well,
a red court.
that is the
Because now
bottom,
IBC.
the ratio of the judgment there is that when an outer limit is provided for the purpose of preferring an appeal, then if no power to condone beyond the same is provided, then it should not be relaxed.
Can never, yes.
Nor Article 226 should be exercised in such a manner to whittle down the various provisions of the statute. So this is what is the ratio which is laid down. So in that event, that's the whole problem, that one cannot have a dual remedy.
But with great respect, it's not in fact a dual remedy, as you also rightly pointed out, because supposing statute provides a remedy and right or wrong, somehow the petitioner couldn't avail that. Now the question is, there's no forum available with him,
No, the forum was this. Had it been a case, there is a complete lack of forum, then one can definitely say that ubi jas ibi remedium is the legal maxim.
Right.
It says that nobody can be rendered remediless. So there must be a remedy under the law.
Correct.
But if the remedy is provided and he did not exhaust the remedy, can he take extraordinary measures to vindicate or ventilate his grievance? Because my remedy which was provided in the statute is lost. I can't avail that remedy. Can it be said?
Probably that may shock judicial conscience, Milords, particularly in the situation. Suppose you also kindly think of a situation. Milords, during the period for Milords' right to file appeal is available. Supposing he is facing a problem which could not, is so Milords intricating that he could not have filed. It may so happen. It is happening, it may so happen. Maybe suffering from cancer, maybe there are some even that
I understood you are really thinking about there is a judgment of the Supreme Court delivered by Justice S.B. Sinha in Kailas versus Nanku.
No, I am on another judgment.
I am telling you the Kailas versus Nanku is the first parent judgment where after the amendment was brought, bringing a particular time limit within which the something is to be done, then the question arose that whether the court can extend beyond it if there is no power reserved. The court says, in a Supreme Court says that in an extraordinary and exceptional cases, the example which you are giving, that was a case where on the last day he was traveling in the auto and the auto met with an accident and suffered a grievous injury. He could not, though holding those papers in the hand. Then the court says that no, the law cannot be so stringent. So the court can, but when the Commercial Courts Act was introduced and there was a stringent provision which is given where the pleading has to be filed within a time frame. The Supreme Court says no, that should be taken as a mandatory period. And if there is no other power beyond it, then you cannot extend the time. Similar situation is that when a period of appeal is provided, and the maximum on the outer cap is fixed therein, beyond which the authority cannot, then in that event, whether the writ court will go beyond it.
So far as scheme of law is concerned, also rightly said, supposing appeal period is 60 days Milords. That is appeal period. 50 days discretion is given to the appellate authority in appropriate circumstances to allow this Milords.
Correct.
Honorable Supreme Court said in Singh Enterprises, that was also repeated in other judgments, saying that when legislature provides for an additional period giving discretion to the appellate authority to condone the delay, then it is not for the High Court under 226 to extend that. So that is in relation to the power, extended power available.
Then I give you an example of Section 34 of the Arbitration and Conciliation. The time limit under Section 34 is given to file the application challenging the award. If the outer limit has already been provided, the Supreme Court in at least 3 judgments have said that no, it cannot be extended beyond it.
Cognizing that our High Court also passed the judgment in law.
What? The Supreme Court judgment is a law under Article 141. How the High Court will take a different view?
Mr. Sao, this is the judgment. The proviso to section 61(2) clearly limits the NCLF's jurisdiction to condone delay only up to 15 days beyond the initial 30 days period, where a statute expressly limits the period within which delay must be condoned, may be condoned. An appellate tribunal cannot exceed that limit. In other words, the NCLT, being a creature of statute, operates strictly within the powers conferred upon it, unlike a civil suit that thereafter all discussions. Last paragraph. Before parting, we may observe that this is the time is of essence in statutory appeals, and the prescribed limitation period must be strictly adhered to. Even a delay of a single day is fatal if the statute doesn't provide for its condonation. As held by us, the NCLT has no power to condone delay beyond the period stipulated under the statute. Allowing condonation in such cases would defeat the legislative intent and open the floodgates to belated and potentially frivolous petitions, thereby undermining the efficacy and finality of the appellate mechanism. This is how Honorable Apex Court put it as this case.
No, sir.
As it's
in relation to discretion exercisable by the appellate authority, or namely the NCLT here, in LND here. But I think that it's a debatable issue. Some judgments are there of the Apex Court because there is a
all the judgments are uniform and pointed to an issue when an outer limit has already been given, beyond which the authority cannot exercise its jurisdiction. Then in that event, there is no question of any laxity or a leniency to be shown. And therefore, it will really curtail. Please look at the object of providing a period, a limitation period for exploring the remedies before the court of law. The object is laudable, that there must be some finality, it must attain finality, and the litigation should not be permitted to perpetually continue for all time to come. That is what the object of the Limitation Act is. It does not destroy the right, but definitely denies the relief. We are more concerned with the relief.
Under similar circumstances.
Section 3, you remind.
Let me check up because there is clear opinion on this matter.
Under similar circumstances, my learned senior was the advocate in case of Lakshmi Construction, which has been decided by this Honorable Court after cognizing the judgment of Honorable Supreme Court in case of Assistant Commissioner LTU versus GlaxoSmithKline Consumer. Your Lordship, also on the last occasion, I have submitted that judgment before your Lordship. And in that judgment, Honorable Supreme Court has categorically said, when the statute does not permit, even under Article 226, read court cannot.
What I am saying.
Exactly.
But that is a
that judgment,
that is a freedom which is enjoyed by a member of the legal fraternity. That he can argue both ways.
Yes.
So we cannot say that what he argued in one case, he is bound by his own argument.
My focal point.
Then I give you my experience there. As a member of the bar, I argued a case before a division bench and succeeded in pursuing the minds of the division bench in upholding my contention. When I departed, my departure from that side of the room to this side of the room, similar point arose, and one of the counsel, he cited that judgment you argued is covered by this. I said I was wrong in my argument. And I took a dissenting view to that judgment and referred the matter to a larger bench, and the larger bench accepted my dissenting view. And matter went to the Apex Court. Apex Court in a very elaborate judgment accepted that and says that can't be the go by the arguments of a lawyer, and he is not bound by his argument.
No, what is the argument today? The same argument was there.
So whatever.
No, this proposition I have not advanced.
That's the law is never standing.
law is about static minutes. That's what essentially I want
It's
to.
an evolving process.
Yes.
Definitely by a passage of time, by the change of the.
Correct. Absolutely
by
correct.
the change in the mindset of the societies, there are many factors which really comes into the play and judgments are being taken. So there is no difficulty, and you can't stick to a particular view. When you come to know of the subsequent law. So that is why we are what, but still, what is the law as on the day prevalent? We have to strict.
Absolutely.
So law as on the day is very
No,
clear.
that's the point on which there is proposition which I want to develop for Lordship's appreciation is because the authority, appellate authority, they don't have any discretion because to even extend 1 day delay beyond the statutory period which is available to them. But under Article 226 such an exigency mirrors, petitioner can remedy less and 226 mirrors read court can examine merit mirrors. But on merit
we
mirrors.
apply this particular principle of remedyless. This legal maxim can be extended to this, that can be extended to a situation where there is a remedy and the party or the litigant failed to exhaust such remedy. Can he take shelter of remedyless?
Minors, that is. Because I find, I will, because I have one judgment.
I will definitely.
Because your Lordship knows the
Correct my
severity
view.
of implication.
My view.
Correct.
I am still, my mind is open.
Mind is,
Very,
yes,
very
your Lordship
clear.
mind is always open.
If I am wrong, then I will accept very boldly that I am wrong. I will not shy away. Because a person should not continue with the notion, wrong notion in his mind. He should correct.
This is so intricating of litigation. In fact, the severity, if your Lordship will gauge where one lands, you will also think of. This many petitioners will suffer because of this. Although the Supreme Court said the judgment which I also want to propose belongs to place that Reed Court in Excel Power 226 will now step into the shoes of the appellate authority to decide the merit only under these exigencies. Because appellate authority has no power to extend even for a day mirrors. I do mirrors. This is salutary law mirrors that nobody can have quarrel on this. Seeing enterprise, this yes, I don't have any quarrel on that. We cannot have any quarrel also. But in such a situation, your Lordship, in appropriate cases, may mirrors consider the case as an appellate authority and merit also.
Perhaps Ananta Panduran, because Sapati you were referring.
And it's a matter to be with all mirrors serious.
Ananta Panduran case, no court can extend the period of limitation. In the garb of exercising Article 226.
Cannot be extended. Limitation cannot be extended. That is without settled law. But now question arises, consequentially to what consequence?
That I gave you that judgment, the first judgment where it says the flexibility, some kind of a
Your Lordship said Banku.
Kailas versus Nalku of Justice as we say now.
It must be decades long back, maybe more than that.
Must be of 2003 or 4.
2003 or 4.
That field.
After many judgments on service
Many judgments have come thereafter.
So many have come only on
that there has been a departure which is, I would say, very seemingly done by the apex court, and where the stringent views, like in commercial courts, that Justice Rishikesh Roy's judgment, it says, no, you can't, it has, you can't go beyond. That's the mandatory provision essentially. Nobody can do it. So this is what the principle really wants. In transport, earlier elections were the first, and there are other transport.
Plea of illusory appellate remedy was taken in Mardia.
Mardia.
That was then.
In subsequent transport judgment on the same issue.
Travancore, I think.
And your Lordship's clear-cut version that which you cannot get directly, you want indirectly. And that,
These are the cases now touching interest of many litigants, those who suffer from all this, and particularly. God. No. Whereas I will check up in detail because this is a very complex issue before Lordship Milords. I will check up certainly all judgments. I will try to find out if there is any escape Milords. Probably your Lordship will be happy that something can be done to the litigant. Because
I can give you a lead of income tax matter where Justice Mohish Shah, when he was there in the Gujarat High Court, he delivered a judgment. What you are arguing was accepted. There also the appellate authority CIT appeals cannot condone the delay beyond a particular time. Thereafter, that was done, and it came before this High Court and says Article 226, you extend the time. Justice Shah's head, yes, 226 is enormous.
Yeah.
There is no matter which is put. And therefore, even if the statutory authorities are bound by the provisions of the law, but the writ remedies are the concept was of a prerogative writs as is prevalent there in the England is not rendered by any kind of a the statutory provisions or something where the prerogative writs can be issued by a court. But there is a gulf of difference between a prerogative writs in the England and the writs under Article 226 in our country. You have to act within the framework of a law which cannot go beyond.
rather 32, 226, 226 is wider. This is wider.
That's it. Wider.
even in Glaxo, Honorable Supreme Court has said what we cannot do in 32, how 226 is on the GST.
There are
that Honorable Supreme Court in that case has said.
It says that the power under Article 26 is more wider than the power under Article 32.
And that judgment I am not submitting because in that judgment the version of Honorable Supreme Court is quite. For that reason, I am on the last occasion I have submitted that judgment, but I have taken back your lordship. Merit, your lordship. Also, he has no merit. I can argue on merit also. I can argue on merit also. Whatever document.
Actually, just opposite to each other.
Your lordship.
And if you combine both of them and for the same on the identical facts, on the identical issues, on the identical grounds, then there
No identical. No identical. Here 74 is based on a report.
dependent upon a fraud and
No, not identical. Totally
Not
different.
identical. Not identical. Not identical. It is a separate. It is a fraud case report.
What is saying for the same transactions, for the
No.
same things, everything.
No, that is different, not same transaction.
No. So I can substantiate.
They could have done in 70. That is
No,
what our
why?
assumption.
There is a
Just
report.
what you said that 73 and 74.
And it is a clear cut willful
Period
mistake.
same Milords.
Keeping 74 pending and then 73 is activated. I just thought on the
No.
same transaction for the same incident and everything.
Period same, issue different
No.
Milords.
No.
No.
73 and 74 can be simultaneously involved.
73 for scrutiny of return.
Oh, I know that. How can it be simultaneously involved?
74 notice has been issued, your lordship.
Yes.
Your lordship, sir.
And
He has
what
justified
transaction?
whatever document he has submitted that has been allowed. And even in this read petition, he has taken the amendment but not enclosed the document and enclosed the document
No, that-
which have been produced before processing
because of
authority, which have been allowed.
No, that is why I have got the invite. Yes.
So, your lordship,
Anyhow, we have been entered into.
your lordship should not.
We
Your
are
lordship may
stuck
not.
at the very nevertheless.
Your lordship,
So let us first overcome that point.
my lord.
My friend is saying, so let it be there. 1 to 17, that's invited.
When we enter into the medical considers, we are stuck up at the
Correct.
nascent
Yes,
stage.
yes.
Please submit.
Tenth of July.
3 weeks. 15th of July.
So may I pray what to, I will take a notice on both mirrors. Both can be. That's a. It's fine. Correct.
Item 17.
Last occasion, I have lost it back. We were also made to me like last direction. Whether the successor has given notice for personal hearing or not, that was the direction and has been given. My lord, I am forwarding my. I am giving also a copy. Yes. By speed post it was. I am not received. By speed post, four notices were given. All those notices I have. Sir. Yes, madam. I have not received. That will come next. Regarding jurisdiction.
Yes, sir. Let us first.
No, I have not received. I have not received the speed
This is
post.
the only point which.
No,
Ask
Must is
them to take instruction.
now take instruction in respect of jurisdiction also.
No,
My
sir.
Lord Chief Justice asked me regarding the doctrine of acquiescence. Because I have challenged the jurisdiction. The authorities have no jurisdiction. Your Lordship may kindly see.
You are thinking that that the hearing was conducted before an officer who later on demitted an office after attending superannuation, and the subsequent officer being the successor, without giving an opportunity of hearing, proceeded to pass the impugned order. So we were under the impression that the hearing was done by one person and the judgment is delivered by another. So how can it be? Because he has not heard the matter.
No.
So we wanted him to disclose whether he has given you a notice. Or if the notice is
I have
given,
not received
if
it.
you choose
Except one.
not to appear,
No.
then in that event, the authorities cannot sit tight over the matter. They have to decide the matter.
I have not received any.
So they have said that you have.
I'll check up.
Post all those notices.
Your Lordship, I will check up.
Personal hearing, yes.
I will check up, sir.
4 fresh personal hearing dates
Yes, ma'am.
and communicated the.
One notice was
by
for
post.
through speed post. I received. I will.
But you chose not to appear.
I will check up. Your Lordship also put the questions regarding accusations. Your Lordship may see.
No. Acquiescence is that a person who is given an opportunity and if he does consciously decided not to avail the opportunity, then why not? The custom of acquiescence will come.
I have
Last you have acquiesced to your right if you did not assert. This was really founded upon this particular notion.
Your Lordship, I have already appeared. Before that.
Appear after the notice was given.
Before his
Successor.
Before the previous authority, I have appeared.
Correct.
Appeared. And I have raised
He
the.
gave 4 notice to you.
Your Lordship, the very jurisdiction, whether they can proceed with their proceedings. Your Lordship may kindly see. Court fee judgments
anxiety. Your lordship also asked me to you.
You don't have duties. Track reports and all, everything you don't have.
That's the instruction.
This is the email.
Please, sir, read the instruction.
By speed post, there must be something.
What I have not indicated?
Whether
It is not the sending. Whether it is reached, it has reached the addressee. That is what we wanted.
my
Where
lord,
is that evidence? You just simply said, your authority has said you have cooperated it.
my lord, it is sent by speed post in the registered
Then show a speed track report.
track report, my lord.
Where is the access endorsement?
My lord, it was sent from speed post.
So, when has it reached? After date of personal hearing or before that? Or you have given him adequate opportunity or not? Where is that? Yes.
Track report, my lord, I can furnish, my lord. Yes, my lord, that
No,
can
When is the postal receipt showing that you have dispatched that notice? There is a gulf of difference between the sending of the notice and the service of the notice. The sending does not mean that it has been served. It may return with certain remarks. So show us the postal receipt that you have dispatched the notice. And then give a track report that it has been served on a particular date. Show us the service.
You taken that.
My
You
lord.
just adjourning.
Lordship directly to me to show the question of acquisition. Doctrine of,
Let us see first.
doctrine of acquisition.
Senior counsel, senior standing counsel.
Senior standing. CT is. Central.
Central jail.
Just make.
My lord, I got it.
This is clear. This matter. When can?
My lord.
10th or 15th?
15th.
15th.
15th of July.
March.
15th July.
Let's call the names.
Item 18.
Minor no correspondence. Same way, no correspondence.
They have not taken any process.
Lordship, that occasion also Lordship directed me.
My lord, he has not made out the case, my lord.
He lost.
The first point is, if the authority who passed an order did not give them a notice of personal hearing, can it be sustained? It will go.
Yes, my lord, that
It's a nullity
yes.
in all senses. Prove us first,
I'll-
then we'll go into the merit. Prove us.
This order is very clear.
Yes, my lord. Whether notice was served.
Item 18.
The lordship is the GST offered by the minor. In absence of GST tribunal,
Registration.
GST tribunal, first.
For the names.
19.
Order this honorable court order number 1. Dated 17th June. Correction.
Item number 19.
Order number 1 dated 17th June. Correction is necessary. Paragraph 2 and 3, that is the financial year 15-16 and 16-17. Both has
Adjournment.
no malice. Like that correction.
Correction, how will you do? Amendment question.
But the order,
Order.
will have to take out an application under section 152.
Have it disclosed.
If it is a ministerial or
Last of it-
typographical error, then look, point out by way of an application.
Last of the direction made to the.
Last occasion, my lords was directed to take instruction regarding the communication and notices to the petitioner. There are notices sent to the petitioner to mail. And the mail is the registered mail ID of the petitioner in the GST portal.
If you choose not to
Not to appear. It was not to appear before his court.
And my lords, this improved order passed on 2nd July 2024. And the annexure 3, the order was passed on 12th July 2024. So this is only my submission that we have done no wrong.
Because initiated by the authority on 21st April, the Aurangabad.
But in Orissa, the so-called proceeding was started on
Subsequent.
7th April 2021, which was in annexure 1, phase 19.
The 73 assessment you have to do in a time bomb manner.
It is time bound now.
Isn't that?
Yes, yes.
How? That was 1 year, I think.
Sorry.
The one you should notice.
My lords.
So, the proceeding within which should not be.
The last notice was issued on 20.
No, if you initiated the proceeding,
Yes, my lord.
you have to conclude within 1 year.
Yes.
73.
71. Yes. And it has been discussed in the page 23, para number 14, point number 14, second para. And the data was received from CBDT jurisdiction letter file number 12.
But this was the notice was issued on 21st April 2021.
Minus.
And this was issued by Commissioner of the CGST and CX, Aurangabad. Thereafter, you have concluded this passed an order on the 12th of July 2024.
Yes.
So after nearly more than 3 years.
That is by Aurangabad.
But
in Orissa,
what is the challenge?
Hello, page 14, my lord.
The challenge is what? To order it at 2nd July or 12th July?
they are challenged the 2nd July.
2nd July.
2nd July order passed in pursuant to the so-called notice dated 24 April 21, and thereafter another notice 30th 6 21. Two assessment, two financial. That is in page 14, my lord. You will number 10. The so-called notice.
24th of April and 30th of June.
No, I thought it is
21. And when the day, what is that? The date is 24. So if there is a time limit within which you have to,
Yes.
and if then you have crossed, can it be said to be order without jurisdiction? Yes, sir. That is the point. Is there a time limit within which the entire proceeding has to be concluded?
Within 1 year.
1 year.
One year.
Your Lordship, 73.
And said that no court should then
Your Lordship.
proceed with the matter, keep it pending.
Your Lordship.
Isn't it?
Your Lordship.
That order.
Both so-called notice as well as order.
But I have another, my lord, there are two assessment.
Point.
I am not raising that point. I am on the point of the two assessment cannot be made. Since he initiated the first
I
assessment.
think it's
So-called.
15, 16, and 67.
Yes, my lord. The 15-16 were already initiated by the Aurangabad Commissioner. And in the so-called notice dated it is 21st April. Thereafter, in 24 April, the Aurangabad Commissioner issued the so-called notice. And he participated there, my lord. All complied.
That is reflected in the earlier order.
Yes, ma'am.
What is the next?
So, my lords, can you come to
Have you seen the earlier order?
Yes, ma'am. That is good.
17/6/2025.
Yes, yes, ma'am.
Para 3.
The annexure 1, regarding annexure 1.
Sir, our order dated 17/6/2025. That's the instructions on that and so on. He is asking on that point. He is saying that subsequently he appeared and the assessment order which was passed in his presence was correct and it is in his favor.
Yes.
This earlier ex parte order has,
We have,
it was not within his knowledge.
yes, ma'am.
So what is your, for the same period,
For the same
two
period,
assessment orders cannot subsist.
my lords.
The assessment order which was passed in his presence, that should remain. The other ex parte order has to be nullified. That is what his.
As per my instruction, we have given several opportunities to be to the petitioner.
Can two assessment orders operate at the same time, sir?
But we have no knowledge about that proceeding is going on there. That is my.
Sir, please look at the point of law, what is to be done. There are,
Both cannot sign.
please consider, there are two orders passed by the authority with respect of
My lords.
and identical issues. One may be an ex parte, another is on contest. It appears that the ex parte order is of a prior time, contested order is of a later time.
Yes.
Right?
Yes.
Now, which one should prevail? It's an earlier order which would prevail, maybe an ex parte, or it is a later order which should prevail. One has to go,
Yes, ma'am.
which one? Or the law permits that the order which inures to the benefit of the SSC has to be taken, and the order which.
That
That's
will be
the law.
Yes.
Here's the law. You want the law, please.
That's
My
that is what we wanted. You are standing for the department, sir. You can't plead that you did not know the proceedings which your department has initiated. How can you plead that ignorance? Party can, but you cannot.
Can a principle or a doctrine of parliamentarian apply in an administrative field?
Ultimately, minors will decide. And in fact, the revenue implication is zero here as per the second order. The revenue
The order which
implication is
was
zero.
passed by an authority on giving an opportunity
Yes,
for
yes.
sharing and then on by recording a reasoned order
Yes.
on the basis of the material which they disclose. And that order,
Okay.
this cannot stand. Pursues the law because that order is of a earlier
Yeah,
period of time.
letter date.
Earlier, that is the latter date.
Yes.
Contested order is of a latter date.
Yes. Because I was some time. Yes.
Still you are, it appears to me from your facial expression, you are in dilemma.
No dilemma. Only one thing in my submission is
Seeing that limitation.
that is not in their prayer. Huh? That is not. That we have given
So
the opportunity.
either way you are billing. If he insists for
That is not
limitation for the earlier one,
Not in that.
you have no case. If he insists for second one, you have no case.
Still, for the department, we have no case for Orissa.
So
Because-
let the Odisha order go,
Yes, my lords.
Aurangabad order remain,
Yes, my lords.
which is the beneficial.
Then I will file one affidavit in this matter.
What for? It's a pure question of law and affidavit is required. Admitted facts are that there are two orders which are there.
Yes, ma'am.
In respect of a same
Period.
for the same.
Turnover
Claim.
one, no, yes.
Now, what is the law? Which would prevail? For that, no affidavit is required, sir. Okay. You cannot deny that there are no two orders.
No.
It's admitted facts. I mean, undisputed facts. I will not say admitted. Undisputed facts. Tell us the law. What?
One.
Attachment is.
Is ready or it is already done?
Already attachment.
Made. No, sir.
Then now, consequences to. What we expect you. What we expect you.
As minors.
Retain the contested order. And that is urgent case.
Yes.
That is appear before that.
Yes.
Yes. Go happily. Bless us.
Item 20.
May please finish. If the petitioner been assessed by both the central as well as the state units on the basis of enforcement information which went both to the state as well as the central GST department units. The state first initiated the proceeding for the same period and for the same amount, and they completed it. I went up in appeal. I lost in the appeal. Then since there was no GST tribunal, I approached this honorable court. I paid another additional 10%, and that matter is pending. In the meantime, the CGST authorities, they issue me a notice for the same people. And this, my lord, in my humble submission, is directly opposing section 6(2)(b) of the CGST Act, my lords. And if your lordship would kindly take up the provision, section 6(2)(b), my lords. Which prohibits, my lord, initiation of the proceeding which the other authorities in saves and of all have completed. Section 6(2)(b). May I just place it for your lordship. Where a proper officer under the State Goods and Service Tax Act or the Union Territory Goods and Service Tax Act has initiated any proceeding on a subject matter
Not on the same subject.
Well, and my lords, on the basis of this, my lords, what you could kindly turn to my annexure 1 begins, my lord, is the impugned order. It begins at page 23. If your lordship could kindly turn to my lords page 29. Lords. Lordship got it? Page 29. I'll be referring to the second table where they say that there's a mismatch of GST and there's an allegation that I have bought these from the fake companies. One is, my lord, your lordship will appreciate MG International. The other one is MS Traders. And the period, my lord, is December 2017, March 2018, and August 2018. And there the amount is also indicated, my lords. Then, if your lordship would kindly turn, my lords, to my lords annexure 4, which begins at page.
Oh, you are concerned with this TASM engineering or?
TASM engineering. What I am saying, my lords, TASM engineering, my lord, was put to this particular assessment because the allegation was that he had bought from non-existent firms basing on fake invoices. So that was the issue on which the intelligence-based action was taken. And the intelligence report went both to the state as well as the center. The center, my lords, I've already same transaction, same subject matter. So, and your lordship have seen.
It's to be applied. How can you go simultaneously?
And now, my lord, so far as the state is concerned, everything is now pending How many books have been issued?
Several issue dropped up the. You know,
Long time back, the former chief justice.
The law is very clear in six, section 6 to be say that if it is already initiated, then in that event you can't proceed. Cannot initiate, the word is initiate. You don't have to proceed. It is initiate.
Initiation to proceed.
It has to be passed.
Let me take it.
You will take care of both the GST and the SGST.
SGST.
Let me take instruction in this matter, Lord.
Instruction was sought for.
No, it's come for the first time.
First time.
It's come.
Or it was on your.
On my
Your
report.
property, not on
Yes, yes, that
Yes,
is page 30.
I've filed that objection, my lords.
Not taken.
And my lords, in a very cryptic manner, he has dealt with it.
Fake invoice, Lords. You pay
It
some.
is just like 140 days.
Your lordship would appreciate how he deals with my objection that the state authorities have already taken it. Page 31. if-
Pre-consultation.
Hello. Lordship in this.
इसको pass an order.
And
Whether to proceed or not to proceed.
you have to initiate.
Initiate. On the same subject matter.
Yeah, let me take instruction in this matter, Lords.
1 week or 2 weeks?
2 weeks, Lords. 2 weeks.
And then don't proceed.
No.
Don't precipitate.
Some interim protection looks advised.
Don't do it.
And Lordship, in this case, what happened, they have accepted that they have initiated the fake invoice and all. And in a defense in reply to it.
They have already been adjudicated by the state.
No, Lordship,
Appeals have been disposed of.
notice was first issued by the central GST.
They will pay, but they will be
Your Lordship,
taxed twice.
initiation was first taken by central GST in 2021.
So,
That's a good ground for quashing me.
yeah, appellate order. You will not respect the appellate order. It culminated in appeal, what he says.
And I have also annexed the orders of this honorable
That
court.
order was carried to appellate authority and appellate authority.
Your Lordship, in defense reply, he has not taken all this call.
Your lordship may kindly turn
Is
to
it
page 31.
30.
How he deals with it, my lords. In the personal hearing, I raised this issue. My lord. He says that some orders were of the High Court were shown, and since the GST tribunal has not been constituted, I don't consider it. Your lordship may kindly turn to page 31. I'm obliged that my learned friend has raised this issue, my lords. Your lordship may kindly turn to page 31.
What can be done now?
Your Lordship.
He says, my lord, he further states that the amount of tax has already been paid and the remain.
It's 31.6.1.
Sure, Lordship.
Paragraph 5 also, your lordship would see. Paragraph 5, the personal hearing has specifically raised this issue.
6.1.
6.1 and also 6.3, my lord.
Yes.
Six-
Very same.
And 6.3, your lordship would see.
Very same person.
Your Lordship, and both.
Right here, wrong. You are not a merit. You are statutory provision.
And let me take instruction in this matter, Lordship.
Which one was earlier? CGST or?
First notice was issued by DGGI in 13/8/2021. Then this order has been passed by our.
23,
And-
That is still.
2023, my lord, the
20.
SGST authorities, they completed the assessment. The notice, my lord, the original notice, that was in 13/8/2021. 13/8/2021.
What was the date of the?
That was Shoko's notice issued by the central authority.
What is? What?
SGST authorities, my lord, they initiated the proceeding, they initiate the proceeding under, the show cause notice. Your lordship would appreciate. If your lordship would kindly turn to page 43. State GST, they initiate the proceeding, my lords, in 22, my lords, and they completed at 12/4/2023, they complete the.
Initiated on the basis of a sub notice, the super notice must have been given. That is
Proceeding.
that is the main objective. That which is earlier. GST notice, local notice, or as GST show cause notice, which one is earlier?
No, they say, my lords, if your lordship would kindly turn to page 43, they received this particular information on 6/2/2021, and thereafter they initiate the proceeding and completed in 2023. So far as the SGST portion is concerned. The CGST, your lordship will call it after lunch.
Notice must have been given.
My lords, your lordship will call it after lunch, I'll give it that information.
Please give that.
My lords. My lords. Mr. Apologize, should have marked it. So it's the first show cause the first notice for the state was 2nd of July 2021. That your lordship would get it at page 44. Earlier the state. Because this show
We have
cause
issued earlier. We have issued earlier.
Then how can you see?
Lord, sir, I verified that all the three notice was issued prior to our notice.
the quantum is also the same.
And amount is also.
Amount.
How can it be? It has to go on that whole alone.
I have to take instruction. I called them, they didn't respond me just now.
Not responded.
There, the lunch time it may be.
Only they have done the investigation. But GK Trading Company, your lordship, it has been decided that proceeding is on show cause notice. Your lordship, your lordship. Madam.
623 orders, orders it. This court has passed in
তারপরে भी judgment, then after also judgments have been, the judgments have been passed when the proceeding has been started and what will be the proceeding. Your lordship.
One day.
Yeah, Lordship.
Only point.
Lordship.
Hey. 21 not. I'm appearing, and the memo. But here, Lord, the already lordship has decided TNB. TNB submission TNB, but only one difficulty is, Lord, here there is no technical glitches, but the negligence of the auditor. And within the parameter of the COVID time, it has been not considered. I have seen and he has signed the earlier auditorship pass. And one notification date has been wrongly mentioned that I am also.
Only fault was the auditor, he has filed the return. And he uploaded the, but he didn't file form 10 in due time. So the fault of the auditor.
Only one now, now, the circular number is wrongly mentioned. I have corrected. Yes, I have corrected and he has also verified. Yes. Much obliged.
This writ appeal just arise out of common judgment belongs because there is for lordship yesterday belongs. Two matters are there. At the back end of the hour belongs, your lordship passed in respect of one and this is left out. Common judgment, same order to be belongs passed. And matter is posted to 1st July now. Along with 9-6, the writ appeal 969.
I'm for the opposite party. So.
23.
Filing my objection.
Here there is a delay of 50 days. 50 days delay. However, my learned friend has filed an objection. 53.
I have no reason as an aspect what happened, my lord,
And your lordship can see what reason they have assigned, my lord. They completely, that judgment was pronounced. No, my lord, what said, they say, my lord, my lord, your lordship trying to see paragraph 3 of the 2. They said that after communication of my certified copy by the Baleshwar municipality to government, they took the step for filing the appeal after the period of limitation, my lord. My lord, this government council was present, participated in the hearing, judgment was pronounced in the open court in presence of the government council, my lord. Government did not take any steps during the period of 30 days for filing the appeal. They said that, my lord, I am placing that paragraph 3, my lord. That the input judgment was delivered on 9/10/2024 and the present appeal was to be filed on or before 8/11/2024. However, the fact remains that after pronouncement of the judgment was delivered on 9/10/2008, the opposition one has applied for the certified copy of the judgment 23/10/2024. And the certified copy was made available to him on 7/11/2024. And thereafter, he was submitted the certified copy of the judgment along with its representation dated 12/11/2024 before the Executive Officer Baleshwar Municipality. I submitted mine. The Executive Officer Baleshwar Municipality in his turn forwarded the copy of the representation to the opposite partner 1 on 12/11/2024 along with certified copy of the judgment on 9/10/2024 by letter number so and so and received in the office on 19/11/2024. That is my certified copy I produced before the Baleshwar municipality. Thereafter, they have taken, after the period of limitation, they have taken the steps for filing. Therefore, I objected that reason they have not assigned that as to why the government did not take steps for filing the appeal within 30 days when the judgment was pronounced in the open court. No sufficient cause has been given. And I have served for 31 years against sanction postman, 29 years against sanction post. This honorable single judge is directed for regularization of my service. That is the matter, plus of the matter. 29 years. Pardon? Yes. 18.
Yes. We'll go through that judgment bill. But let delay be cut down because fact and circumstances are different, rules are different.
The counter affidavit is filed by the
Yes. That one not one.
against the application for according to the counsel for the opposite party, there is no sufficient cause to instead application for the resolution of the game, warranting the discretion to be exercised by the court. This further submitted that there has been a gross lapses and or negligence on the part of the applicant in pursuing the matter, and therefore the application for confirmation of delay is the dismissal. It appears from the government's making on this application that the steps have been taken after the in 2000 and on obtaining the certified copy thereof, the draft appeal was finalized by the additional government, and thereafter it was filed within a close proximity of time. The procedural hazards and the procedures to be adopted in relation to an appeal filed by the state or its instrumentality is not unknown. We are conscious that the court should not make any discrimination between the state and the individual, as they stand on the same pedestal. Yet the court cannot ignore the fact that if certain procedures are provided in order to take a decision for filing an appeal, if the time is consumed, it does not appear to be allowing. The court must encourage the litigation to be decided on grade, then to be made in part on the contour of the laws and conditions. We are satisfied with the explanation offered in the constituting a solution called in preparation, in not preparation, I think within the period of application. So the application is allowed, the dealing filing the application is rather open door. Let the rate of fee be listed.
A copy of the
For admission.
copy of the writ appeal
The
will
copy of the writ appeal will
By
be,
tomorrow.
shall be served for in course of this week.
First week of July. First July. 1st July. 24. Item 24.
Item 24. There is a period of 1,742 days.
What to do?
But here, my lord,
More than 3 years.
instead of filing appeal, state directly challenged the order passed by the Honorable Single Judge before the Honorable Apex Court. Initially, the Honorable Apex Court granted stay of the judgment. Then subsequently, the matter was taken up with another case and was disposed of with this observation. Your Lordship, I kindly see the Honorable Apex Court have held that that is
Oh. Why don't you put it, because you are taking advantage of section 14.
Section 14.
When you are taking an advantage, you will have to plead. The time consumed
Before the Honorable Apex Court.
pursuing the SLP,
That ground is taken in the, that ground is
then
taken.
why you did not annex this order? You ought to have.
We have mentioned it, but somehow.
Yes. So the court has, the Supreme Court has granted you liberty to avail the benefit of section 14. So will you not? We have, when you filed these special petitions, what orders were passed in the meantime, and what has happened ultimately?
This is the last order by virtue of
This
which the
order, this is the order dated 23rd of August 2024. And when you preferred an appeal,
that date was filed.
After 6 more than 7 months.
when you preferred, what is the date of institution of this appeal?
2025.
So what you were doing from August to March 2025? What is the explanation given?
Because your appeal or SLP.
There are three of my.
Yes.
What is
Was
the
your SLP. So that August and you have instituted this, you have prepared this appeal on 19/3/2025.
After 23rd of August, what you have done? When the apex court permitted you to withdraw, you can take the advantage of section 14 for the period where the proceeding was pending before the
Pending before
Supreme
the
Court from 2022 to 2024. You can you are entitled. But after the August, what has happened?
Further delay must have been explained in detail.
There is nothing.
This was your file, the diary entry was 15 January.
So September, October, November, December, 4 months. What is the explanation which is given?
Para 4
Sufficiently evaluated. And the process, the filing of rate appeal. You are filing the SLP, you had the reports. The SLP was your also. That was dispute. Liberty was granted. So there cannot be any further delay.
There is only a delay of 4 months.
Only. What can you say? It is God, especially it's called dispute.
Withdrawn with liberty.
What liberties?
The Irish days.
Yes.
That was serious defect. You are not stated then that order came to your notice after the disposal there. Who dealt with that?
May be permitted to file a better
And what
application.
action you have taken against the running officer?
Shooting over the
So,
May be permitted to file a better application.
What's liberty?
Fully explain.
And now Suraj Singh judgment has been diluted to a great extent now, subsequently.
But the observations in Sivraj Singh.
So I'm talking about the subsequent judgment of the Emirates Court by Justice Pankaj Mittal, then by Justice
direction. They have to.
Justice Padiwala.
Each day delay was
Each day delay
Not
after
each day.
but plausible reasons have to be.
There must be a symmetry of the events. That is lacking.
It may permit me to file a better application because they have the IA application. I will not press. File a better application with my lord's permission.
permission is required.
Yes.
And they are not short copy. I have nothing to say. Not short copy there. Even the appear, but not no copy short.
Simply be adjourned.
Let them have short copy. I'll file.
They are adjourned.
You have not been served with a copy of the delay application.
No, because today it is listed for the first time. That is why
Served with a copy.
I'll serve.
Service upon him who appears. So we are permitting to withdraw. He does not want and with liberty to file.
And your lordship.
Okay, sir.
Fact remains, I have continued for last 15 years without regular schools. I will return only within 2 years. Only plus year.
That is trying to intend to withdraw the instrument application as it contains a matter which is incurable in nature and to file the with liberty to file the fresh application for the sunset release.
With copy to.
What do you want for?
With the fresh application.
Yes.
May I bring this order?
Is the appears for the requisition of the time. Submit the copy of the application has not been served upon. This is the applicant intends to withdraw the said application. Since we is granted. In the event. The fresh application is filed for the self-release, the copy whereof shall be served upon. The suggested, well in advance.
But this order may be passed to only the IA.
IA, yes, IA.
Yes.
Yes, talking about application.
My.
Record IA everywhere.
Item 25.
The last order. Last my lord's order.
If there is a delay of 90 days. After receipt of the objection, we have filed our reply to that objection, explaining the delay. that has been caused. And only on the question of delay, my lord, I have a glance to this list of dates.
May I suggest, my lord, 90 days delay. But what I'm trying to impress upon your lordship is, no, let the matter be taken up on merits and delay the lordship definitely will.
What is the merit of the matter? What is the subject matter of challenging the order?
Declaration of service.
Okay. After, now we have already delivered a judgment on 18th. You have to go through it. We are just keeping the case. It is fair that if you take a matter by merit, then
I have a concession for permission.
The delay be controlled and
come on first.
first of July.
First of July.
Those will appear as IA, but we will, that's an understanding, we will argue on merit.
First of July.
Lordship can also condone the delay.
Not necessarily, yes, simultaneously, sir.
Must.
And regularization, why is it coming in every case, single bench, after division bench has passed the orders of.
Here, the matters are of different departments, different rules and different.
What is the source for a gather is a source for a rules. You can't say that different departments will have a different. These are all the instrumentalities of the state. They have to be bound, they are bound by it.
That was 85
We
Indarpal.
have passed, drivers we have passed, data entry operators.
Every outsourcing even.
LPH.
Multi-purpose.
Alibaba is also there.
We have passed.
Indarpal Yadav, 85, as back as 85 law is settled.
Some cases.
Like 85, after that, lot of changes has come after 2005.
I'm asking Indarpal in the context of discrimination. Not.
That is what we have.
Look at
My lord has
the
authored. Today it is.
18th June, we have authored government. I do not know in what matter, I never remember the name.
Arun,
I used to remember the name of one party that was on that side. Obvious reason was to remember his name.
Yes.
But after
It was the
departure,
bounded
now I do not-
duty to remember. So we are coming back on first of July. Great.
Item 26.
Yes, sir. Delay 213 days.
Only 10-day delay, my lord.
10 days.
210 days.
200, he says 10 days.
10 days, right?
10 days.
212 days. 212 days.
Well,
Our registry has.
No, sir. What is the explanation?
the movement of file, there was delay, my lord, and that's it.
I have already filed a objection.
Yes.
That if no.
Let us decide Siura Singh's case, whether applicable. Can't take advantage of the privilege which is given to a government. You are not a privileged litigant.
After contempt, there are findings. They have considered that there is some time we will come back to it. Instead of complaining, you have come to. Before the learned. Before the learned single. No, sir. Content.
Thereafter, my lord, second contract I already filed. Thereafter, he filed 1/3/25. There is a writ appeal. Before thereafter, second contract. Thereafter,
your objection? Have you stated everything in your objection?
yes, my lord. I have already started my. Yes. And unmarried daughter and unemployed.
Well, the poor person has engaged the counsel of your stature. Can you believe he is a poor person?
Entire period he was on ad hoc basis. Actually, they are appointed in regular post.
Case is also pending, my lord. That was
Have you enclosed order in first quarter? Please see that.
Yes, ma'am.
There you have considered that you will give some time, you will comply. So on that assurance, perhaps that order was passed.
Yes, ma'am.
And further line is there. You see last line.
Yes.
If you don't comply, then it will be treated to be deliberate
Contempt, ma'am.
content. So then it will be live thereafter. Can we sit over that?
So for
dates. Just from the date when the judgment was delivered, then you have communicated them. Despite the communication, they did not do anything. Then a contempt application was filed. When the copy of the contempt application was served upon them, when they entered appearance in the contempt, and then ultimately the judgment is the contempt, then steps what they have taken. These are the relevant dates which are important for constituting a sufficient cause, whether it is a deliberate attempt to file or if there was a bona fide.
your lordship may kindly show the 5/5/25 order. Not being satisfied with the existing limitation petition.
We are concerned with the order dated 2nd of July.
Yes, ma'am.
Correct? So the 2nd July order is already there. You are challenging that
Yes, ma'am.
by filing an appeal in 2024.
Yes.
Now, they might have communicated this order to you.
Yes, ma'am.
Otherwise, the contempt application would not have been filed. Then you were given a notice in the contempt. You appeared before the contempt court. Then what steps? That has to be taken into consideration that what you are pleading in your application
whether that can constitute.
For a better application, your lordship has directed in 5520 to 5 rejoinder to his objection, my lord.
No, better application.
Rejoinder means objection, rejoinder to objection, better application.
Reply to the objection.
Yes, my lord.
That is a treated, not counter affidavit in a strict sense.
So that application we have not filed so far. We are written letter to the department and let it come next week. We will file the application. Rejoinder. Collector passed order for termination because he was held up in a vigilance case, my lord, a trap case.
That order already
That ended.
clear. Subject to result of which is.
No, confirmation is the appropriate order. The resolution is 1276. Do that. 1276. Do that. Letters of discussion. This is 21.
Further affidavit you said directed to file 85 will file next week, my lord.
What further affidavit you will file?
By order dated 18/5/2025, your lordship passed an order to file a rejoinder further to the objection filed in it. That is probably a petition and improvement.
Rejoinder is permitted to file a rejoinder, but
However, improvement is the limitation petition.
Reply to objection. Not
it is only a reply to an objection which he filed.
That has not filed but written to the department, what it come. Let it come next week, man. After formal objection.
Stay, it is up to you.
After formal objection, you will have to.
Second contempt is taken out.
4 times.
Second contempt is taken out.
No, my second contempt I have filed that is second contempt. Thereafter, he filed read up before read up. Second contempt
is not listed.
No, not listed. Thereafter, he filed one first marks. Read up.
Proceed, whatever. Proceed in your way. You wanted a time. On the prayer of the
Those for the university, the price is which was a big extension by a week from.
Reply to objection stated so.
Reply to the objection point by the.
Next one.
By a week from those, this the matter that.
Weeks.
All the names.
8th of July. Item 27.
You already have the matter of 20th. Is that matter, my lord? Matter 20th, that matter the document was not supplied, and the respondent matter. And Monday for orders.
The day after, just president day after tomorrow will be.
26th. 26th. Delivery. Day after 26th.
Delivery funds.
We will finalize that, we will pronounce the order on that.
Mike.
Item 28.
Please, my lord, I appear for the appellant. There are, my lord, two issues at the outset. The first is confirmation of delay of 12 days.
12 days. Yes.
So that if your lordships kindly may
Yes. Have you given
condone that delay of 12 days.
Have you given a notice?
Yes, sir. There's an IA filed, my lord, as well served on the other side.
Already filed or copy served,
You have served.
Yes.
12 days.
And the second issue, my lord, is the application for stay, which for us is somewhat, my lord, worrying and urgent. Because 365 deaf and dumb students have been ordered to leave
I
the.
understand, but unless the condemnation is done.
Yes, my lord, yes, I understand that.
So there is some kind of a hurdle under Order 41, Rule 3A, Sub Rule
Yes,
3.5, that the condonation, unless it is done, the stay should not be granted.
No, I understand, my lord. I agree also with that. But I'm asking if after you
To condone, first to condone the delay.
Yes, my
What
lord.
do you say about 13 days?
13 days, my lord, and
Which
this,
is the application for condonation?
yes, my lord. That
Which
is
one? IA?
2891.
2893.
Part B. Personal difficulty.
What kind of a application you are making? This is a condonation?
It's a little cryptic when I saw it today. my lord.
No, I'm asking to your junior advocate on record. He has drafted it.
I got.
So, don't you know that what may constitute sufficient cause, what may not? What is your responsibility when you plead the condonation? So cryptic and in a casual manner, you are drafting the section 5. As is a matter of course, the court will condone the delay. Some personal difficulties, some communication gap would not be fine. Is it a good ground? Will it constitute a sufficient cause? Tell us. And you have engaged a senior counsel to argue.
On merits.
Maybe first you have to pass the hurdle of the section 5. If it is dismissed at that stage, then what the merit will do? Very in a cavalier manner, this is what the draftings are done.
We apologize, my lord, for that.
This is an application for condonation of delay of 12 days in preferring the instant appeal against an order dated 11th March 2025, passed in WPC number 6457 of 2025. Stop. The learned advocate appearing for the state opposes the application for condonation of delay. Stop. After perusal of the amendments made in paragraph 2 and 3 of the said application, we find that the applicant was prevented by a sufficient cause in not preferring the instant appeal within the period of limitation provided therefore. Accordingly, the delay in filing the instant appeal is hereby condoned. Is that it's only 12 days that we are condoning, otherwise is hereby condoned. The application being IA 2891 of 2025 is hereby allowed. Now, what is the matter about?
I'll tell your lordship, my lord, this is a matter relating to, my lord, the education of a senior college for deaf and dumb students, which is run from government quarters in Bhubaneswar.
Why, sir, you are using the word dumb?
Yes,
now
sir.
We don't use the word.
Yes, sir. Yes, sir.
The glossary of
yes, sir.
The book which is published by the Supreme Court.
Yes, brother.
Does not use this word dumb. They're not dumb.
I stand corrected, my lord. Totally, I don't, and I should know better, my lord. I should.
Yes.
Yeah. So, my lord, the hearing impaired students running to about 365 students.
Hearing and speech impairment, I can.
Both. Yes, my lord. In this case, both hearing impairment and speech impairment. My lord, studying in the Senior College of the Petitioner Trust, which is a charitable trust in Bhubaneswar. College has been established in 2007, but in 2018, we got recognition and so on for the senior college. So the senior college that we are running is fully recognized and so on. Now, my lord,
There's a list. Written notes.
List of events. Yes, well, I've given you a list of dates to carry us through the case on hearing whenever it is done, whenever your lordship.
Yes.
Degree college. Degree college.
Degree college. Only one college in the state.
Yeah, and my lord, yes, my colleague is right. It is the only college in the state of Orissa, senior college for the state of Orissa for the hearing impaired and the speech impaired. So, my lord, we start in 2007. 2018, we get recognition and permission, so there's no problem about that. But we get recognition and permission for a junior college. So we start a junior college at Bhubaneswar. Then, my lord, that college is upgraded to senior college. A little dispute exists between us and the government. We say that you gave us permission for the same place, that is to say, Bhubaneswar. They say something else, that no, it was only for junior, whatever, my lord. So junior and senior ran in the same place. And a few years later, my lord, we shifted the junior college to our own building and our own property in Kolta. And the senior college runs today at, my lord, this building. Now, my lord, there's a objection taken. Why are we running the senior college for speech impaired and hearing impaired people when we gave you permission only for the junior college? And there's a dispute over that because our recognition for the senior college gives the address at the same place, and we ran it at the same place. And in any case, my lord, I can't see what harm it causes the government. We run with our own money. We don't have grant and aid. They gave us the premises, and 365 students are now studying in that. And, my lord, further, from our junior college now, the students have graduated. They're coming for senior college, and there's not a single institution for such students, my lord, in the entire state of Orissa. So I'm doing something which is perhaps good for society in general, but particularly, my lord, for the hearing impaired people and so on. So, my lord, that is the long and short. Now I get an eviction notice. I want your lordship to see the impugned order and see whether, my lord, I think the government should really take a relook as to whether they want to stand by this reason for evicting us. Even assuming it is correct, I'm contesting that it's not correct. Senior college was given permission to operate in the same premises. But let's suppose there's some misunderstanding or whatever. Just see whether, my lord, this kind of, see the impugned order. Show me the impugned order.
Yes.
See, my lord, the impugned order and go straight. It's actually, my lord, I think, a non-speaking order because it sets aside, my lord, it reproduces our stand and it then reproduces the government stand at, my lord, page 47. This is the government stand in its page 47, my lord. The relevant portion of the order dated 17/2/25 issued by the rent officer. Lordship has that? My lord has that?
Yes, yes.
Yes. After carefully going through the connected documents and understanding the flow of events, I found that the +2 wing, that is, my lord, junior college. Yes, sir. After carefully going.
Additional 15 machine, my lord. We are shifting it to integrated complex at Jotli. And that the decision of the.
Just 1 second, sir. Let me complete reading of the document.
I appreciate. Don't take it as a final opinion express, but there are one thing. What I find from the impugned order, that not a single reasons have been provided.
Yes, sir. It's a non-speaking.
Not a single finding has been returned.
Yes, sir.
On the merit of the other petition. He simply recorded the submissions. He simply recorded the submissions of the petitioner, and then say abruptly jump to the conclusion, in view of the matter, I am dismissing the writ petition.
Yes, sir.
running into paragraph, up to paragraph 6, I do not find any independent finding is made by the judge.
Yes, sir. Yes.
Paragraph 1 says matter is taken in a hybrid manner. Paragraph 2 is a reproduction of the writ petition and the prayer made therein. Paragraph 3 is a hearing of the parties. Paragraph 4 is a submission advanced by the petitioner. Paragraph 5 is a recording of the fact or the pleading that you started. Paragraph 6 is a submission of the petitioner. And the latter portion, the authority rejected their application with this finding, and he quoted the finding. And then paragraph says, in view of the matter, I am dismissing the writ petition. Where is his independent finding?
Yes.
If he accepts the decision of the government or the authority, he has to say that, yes, I accept, for these reasons I am accepting. He simply quoted the decision of the authority and then abruptly jumped to the conclusion, I hereby dismiss the writ.
Annex 15, the authority who passed the order has stated and given the reason that city.
But yes, to when they have challenged the reasons on a different parameters, will he not record that why I am not accepting the contention of the writ petitioner? I am reminded of those line of judgment which says that the order bereft of the reason is no order in the eye of law.
Your lordship will dispose of the appeal in the direction of the authority.
Correct, not authority. It will go back to the single bench for fresh decision. Record the findings.
Okay.
Why we will? The authority may be correct. No difficulty. But the single judge must record the reasons.
Single judge would have taken consideration aspects dealt in Annex 15, my lord.
But he has not reflected.
Yes, my lord.
He should have recorded that I have perused the paragraph, the Annex 15, wherefrom it finds these are the facts, and on the basis thereof, I do not find that the findings of the authority is wrong. I could have appreciated 1 line, 2 line reasons have been given. He simply quoted what the authority has held and then says writ petition dismiss. That shows that he accepted that, but there must be a finding returned. No.
And the government
By the consent of the respective councils, the mean appeal is taken up for hearing. Stop. By the impugned order dated 11/3/2025, the writ petition filed by the appellant is dismissed with the following observations. Quote the entire order. Stop. The order as reproduced herein above does not appear to have contained any independent finding by the single bench in arriving at the ultimate decision of dismissal of the writ petition. Next map. In the adversarial system of adjudication, the importance of providing the reason is indispensable. Stop. A litigant has a right to know the reasons for negation of his claim. Stop. It is a fundament. It is a foremost duty of the court while adjudicating the claim. They are adjudicating the rival claims of the parties to record the independent findings on each and every issue so raised. Stop. The reason is thus regarded as the heart and soul of an order without which it cannot survive. The reasons further provides an opportunity to the higher forum to decide the appeal. And the points so involved therein. More particularly, what swayed the mind of the learned judge while rejecting the claim. It further augments the transparency and the fairness in adjudicatory process. And the litigant would be benefited with the reasons made in his favor or against him. The order bereft of reason is always regarded as an order, is regarded as no order in the eye of law. Stop. Solely on the ground that the order lacks reason, far to speak of a proper reason, the same cannot be sustained. The order impugned in the instant appeal is hereby set aside. The writ petition is restored to its original file and number. We request the learned single judge to rehear the said writ petition and dispose of the same as expeditiously as possible. Stop. None of the observations made here in above shall be construed to have any impact on the merit of the writ petition, as this court has no occasion to go into the above aspect, and the impugned order is interfered with solely on the ground that it lacks reasons. Stop. Appeal and applications are disposed of.
Yes, and my lord, kindly, my application is also, the order refers to the order of the government evicting me, that is 17/2/25.
Sir, we have set aside the impugned order and relegated the matter to the single bench to decide afresh. If any interim order is required, you can approach the single bench for the same.
Please, my lordship may kindly say that.
No, we can't. That's always there. That's I would say, the statutory right. No difficulty.
Please.
Yes. Come.
Great.
Next matter.
Item 29.
Yes, sir.
It's item 29. Pursuant to interim order, your lordship, 51% continuing his job with the opposite party, my lord. 51% continuing his job, my lord. So, my lord, there is a numerous application is filed. So I want application counter agenda. So I want file a soft date chart.
What is
date chart short note?
Date chart short note. What does it mean? I'm unfamiliar with this terminology. That's why I want.
Date with the date of events.
That means the list of dates.
Yes,
you wanted to say the list of dates or the list of the events.
Yes, Lord.
In a chronological manner. You wanted to.
Yes, well, fine, because
for that the adjournment.
51% is continuing. If any adverse will they will be jobless.
So what do you think, that you can't place your case? We will not understand without the What that
Well,
word?
I am not able to submit.
Date chart. Without that date chart, we can't.
I may not be able to satisfy. But only next week.
Subject to the prayer, my lord, since last 5-6 occasions, they have been taking time.
No, he is not with the state, my lord, the corporation. It's not the tender invited by the the open over 2 and 3 years.
Contract has already terminated and he's.
Kill your formidable opponent first.
You are day by day strengthening your quality of arguments.
First,
By reading the.
first meet your formidable opponent first.
They have not yet filed counter affidavit statement.
File a counter.
And state has not yet filed. Open number 1 has not yet filed your lords.
It's already been filed, my lords. It's
See,
there.
everything she's saying you are factually incorrect.
No, my lord, your lords, go ahead.
25,025, it has come on the court list.
There's a 2 by 2 and 3 your lords.
24, it's mentioned in the court list, my lords, on 25/4/2025. Counter affidavit has been
No,
filed.
I have not solved.
My lords, I myself have filed this out.
Then
Look,
24/4/2025.
I have not solved.
He filed on my lords and myself, my lords have filed this.
Only
yes.
No.
Are you not verifying your brief from that equipment? You could have very well know before she points it out.
Because my lord, the counter
When it is
agent.
ready for hearing, you are just saying that you are not received. Will you not verify
Yes, sir.
your brief? What are all the documents available there before us?
The only melody your lordship they. Where the only counter affidavit filed by the 2 and 3 melody. One is melody they have filed April. We have not solved.
2025, my lords, it has been reflected, it's reflected 25/4, my lords. And my lords, there is an RA for vacation of the interim order. My lords, the interim.
Your lordship, the counter affidavit dated file opposite to the flag C, your lordship. They have dated counter, just counter affidavit dated 24 April 2025, filed by the opposite party at flag C. Second copy not filed. We are also not solved that copy. We believe that the tendering authority 2 and 3 filed.
We have filed the law.
You solved the copy next week, my lord. I have not.
Yes, give a copy.
Have you given a physical copy to them?
My lord, just check with the department, my office, my lord, because it was filed in April, my lord.
Must be there in your record, madam. You see whether
They must have put the signature or something of.
your registered clerk must have served or not served. Has he not recorded
Communicating letter.
on sheet? Then
My lord, if I may request.
you have to verify that
My lord,
whether you have served copies or not.
My lords, it was listed on 17th, my lords, therein also this same thing was reflected. On that, they did not object to this.
Not necessarily you should verify whether you have served. It is your duty to serve copies. You should verify.
My lords, if I may request, it might come day after, my lords. I will immediately serve it, my lords.
Today, so you serve today.
Today, my lords, I will immediately do it, my lords.
Mr.
I have filed my lord, the tender inviting authority, they have filed their counter affidavit, my lord, way back in 24/6/2021. my lord.
That I received.
We have also filed the vacation of stay application. So what I humbly pray, my lord, if my lord is taking time, let the counter be served upon him, but let the matter be taken up on Monday, my lord.
And any earliest date as per my lords.
Monday. Take it.
We will be direct to South today, please.
But I will serve it right now.
Yes.
She is giving an undertaking to serve it today.
Yes, sir.
And come ready.
Yes.
$30,000. Item 30.
In this matter, on the last occasion, you will see the amendment has been made, you will see. And I have already filed counter in 3 amendment stage. And your lordship post amendment, I have taken time, your lordship, I have received the copy and the consolidated copy, your lordship. So your lordship, one accommodation, 2 weeks time will be granted for filing of additional counter against that amendment.
Only restricted to an amended.
Your Lordship, because originally I have filed the counter, meetings have been completed, he has filed rejoinder. Only the additional.
That's a right. That's a valuable right. You can't take away that valuable right of the additional written statement after the amended plaint is filed.
Correct.
So
That's one more thing, Your Lordship. In the meantime,
2 weeks.
Your Lordship.
8th of July.
Validity of 16 to
16%. Your Lordship, this matter may be the lead matter, and some of the other matters are there. So far regarding the constitutional validity of section 16(2) subsection C, Your Lordship.
So if it is a lead matter, then you will be a lead arguing counsel.
Your Lordship. Your Lordship, that will be my
In
pleasure.
fact, earlier directed all 16 matters to China together.
Your Lordship, on the last
Taken up.
occasion also I have given some of the read petition to those who have been entangled. Your Lordship, those cases.
Not entangled. Entangled as a negative sense. No, entangled.
It's not
It is used in a negative sense.
Yes, sir. Yes, sir. In this matter, I have filed an IA bearing number 8568 of 25 for modification.
Modification of?
Modification of earlier entry order.
Passed by?
Passed by this honorable vehicle. What will happen? Yes, sir.
Which one? Which IA?
IA number 8568 of 25, sir.
8568.
68 of 25.
20%.
There was direction.
Now amendment has come that 10%.
No. I only say, my lords, that's 20% tax, is not interest, my lords. Your lordship, my lords, one order I am giving to you.
Tax and interest.
In 16 cases, Your Lordship may kindly look into the previous order, what I have submitted. Just now I have submitted the cases on.
Mr. In every case, we are budgeting for tax only.
No, tax and interest.
I'm giving copy of
Your Lordship is a part of that order. Your Lordship, tax and interest. Your Lordship consciously has passed the order.
No, this is earliest one.
No, all these matters.
One, thereafter in some other cases, we have part of that.
Yes,
is
in
20% on
this
tax
batch,
only.
in this 16(2)(c) batch, Your Lordship has passed categorically tax and interest. Enter that.
No,
Not
that.
Mr. You see, this was when I was newly got. Right. Thereafter, I think subsequent succeeding benches, other benches maybe, they have restricted it to tax only.
That is non-constitution of the tribunal.
I have given a copy to your lordship.
Matter.
Yes, I was part.
Yes. Particularly, I don't know what prejudice will be caused to revenue, but in this case,
the interest component has to be deleted. Is only on the basis of yes.
Then all of the parties will be prejudiced.
No, not
how the order will be.
Please. I will deposit 20% of the tax.
Yes.
And you want this interest to go.
Oh, yes. Only to that extent to modify. And
standing for citizens. Recommendation to file additional counter with respect to amendment to this restriction as announced. Yes, this matter is enabling him to file counter. I was not disposed.
No, it was directed to be listed today.
The I. Year 2020. At paragraph 10 of audited 2/5/2025. This court has observed as follows. Sri Jagan showed that senior assistant subjected that the in order to comply with the said the petitioner has already deposited 20% of the demand of tax.
Excluding interest, excluding
That's
Tax.
that's in submitting. It's in getting.
He rest of the interim to tax component as is done by the interim models possible for many other petitioners who have raised similar issues as that is involved in the present matter. Considering the submission made at the bar, subject to verification by the bar. The petitioner has deposited 20% of the demand of tax. The no coercive steps for recovery of the balance amount shall be taken by the public finance till the next date of. He understands this.
Yes.
Lordship, my matter.
Just a minute. That 20% we.
May be subject to verification.
I have said that. Sorry, subject to verification.
Lordship, my matter was similar, identical. I also try, I put modification with 8.14.
Which
item number 58.
Item number
48.
48.
Don't worry, we will go there. Don't worry.
Thank
Call the next.
Item 31.
Why it has appeared? There is a mistake in the date, nothing more than that. Yes. 2 weeks.
8th of July.
There was a direction to submit the CCTV footage, my lord. That's there in the file. If I may hand over the single server of the CCTV footage.
When that order was passed.
My lord, 6/2025, and there was an instruction because we are relying upon the CCTV footage, and the CCTV footage was never seen the light of the day that was recorded in the order, my lord. 6/2.
But it has to be accompanied by certain affidavits that you should bear the responsibility of its genuinity.
In the sealed cover, my lord, that only it is that. In affidavit, we have mentioned so, my lords. In our counter affidavit, my lord.
The counsel for the petitioner prays for an accommodation. Stop. The counsel for the state submits that pursuant to the order dated 6/2/2025, the state may be permitted to file the CCTV footage recorded in the pen drive full stop. We had an occasion to peruse the tenet of the order dated 6/2/2025, wherefrom it appears that a serious allegation was made by the petitioner against certain officers or a persons working in the department who are allegedly indulged in corrupt practices. Full stop. Since the liberty was granted to produce the same, the CC footage, let the same be taken on record. Since the adjournment is sought by the petitioner, let this matter be listed after 2 weeks.
8th of
Give
July.
a date.
8th of July. 8th of July.
We have recorded that you have filed. Yes.
Item 32.
On behalf of Mr. A. Lordship, there is a matter relating to upgradation and the rehabilitation of the national highway, that is Cuttack HON'BLE Road, Your Lordship. Also, on the last occasion, the opposite party number 2 had taken in their affidavit, they had stated that, Your Lordship, the road work is to be completed by the end of May 2025, Your Lordship. And now it's June 2025, Your Lordship. Till the date, they have not taken any action regarding that.
Yes.
Yeah, please, Lordship.
Yes.
Order number 8, my Lord.
This is what I am reading, order dated 26/3.
Yes, my Lord.
You have
Last
said
occasion.
that complete the construction
Yes, my Lord.
by May 2025.
Yes, my Lord.
So-
Undertaking the
So on 23rd June, it was directed so that.
Yes, ma'am. I accept for instruction, my Lord. I have received the instruction. What's if they allow me 10 days time and file in the form of affidavit to bring it on record, my Lord.
What?
The instruction which I have received yesterday, my
What
It says,
instruction?
my Lord,
Have you completed or you are not completed? Tell us.
98% work has been completed.
90?
98%. The
Okay.
remaining 2% is, my Lord, regarding the de-scoping of work, which could not be completed. We need to have authorization from the headquarters. Next, regarding, my Lord, shifting of the materials which are lying over the incomplete work, my Lord.
Shifting over of
Shifting of the materials, my Lord.
materials.
Yes, ma'am.
Okay.
That's why Lordship may form. I'm showing the photographs, current photograph, Your Lordship. The road has not been completed till the date, Your Lordship.
No, he says 98%
No.
the roads have been completed. Show us. What is this photograph?
There is a drainage area in Lordship. The water logging is still going on, Lordship, and
No, the road is already completed. It is a side drain which should run along the road.
No, Lordship.
So that is the
As
difference.
it is a rainy season, Lordship, the local.
Maybe, sir, main thing is the construction of a road.
Of the national highway.
This is already done.
But in their affidavit, Your Lordship, there.
So no,
stated
this
that
road
by
is already
end of 2025 only.
And there was no direction for the drainage system was not done.
Yes, Your Lordship. If I submit, my lord, in the course of the execution of the tender, my lord, there have been lots of requests from the local representative as well local persons, my lord, which we had to to satisfy them, to pacify them, my lords. It includes a overbridge which was never in the scope of the work, vehicle underpass, my lord, the drainage systems, few drainage system, my lords, which NHAI has undertaken, and the work is on the verge of completion, my lords. So what remains is just a few descoping of the work, removal of the materials, and if few construction and the final works remain, my lord. So on the words of completion, my lord, that's why I'm saying I'll bring it on the record, my lord. Lots of my lord, just 10 days time, my lord. I have received the instruction.
The matter was directed to be listed today as the council representing the opposite parties
True instruction.
took a stand before the court on 26/3/2025 that the project is expected to be completed by May 2025. Stop. The counsel for the petitioner submits that despite such assurance having given to the court, no work has been undertaken by them. Stop. The counsel for the opposite party submits that the 98% of the total project has already been completed, except what is this? Decommissioning or what?
Lots of descoping. Descoping of the work.
Descoping of the except
And
the descoping and the removal of the materials. Stop. It is further submitted that the fringe work is required to be done, which would not consume much time, and seeks liberty to file the affidavit disclosing the aforementioned facts. Stop. We have been taken to a photographs sought to be relied upon by the petitioner, and find that there is some excavation work going on along the side of the rod, which appears to have been constructed. Stop. Let the said photographs be handed over to the learned advocate appearing for the opposite party, so that an appropriate instructions can be received from the responsible officer. Stop. It is expected that while filing the affidavit, the opposite party shall deal with the same. Deal with the photographs relied upon by the learned advocate for the petitioner. How soon?
2 weeks time, my lord.
2 weeks time to file affidavit.
What's it for small prayer, my lord? It's a long stretch of road, my lord. If the petitioner can mention which part of the photograph has been taken, my lord.
Your authority is known which part it is.
Grateful, my lord.
All the buildings and everything is there.
I'll do that.
Yes.
I think GPS. GPS.
Yes, ma'am. I'll do that, my lord.
Yes. Next.
Grateful.
Item 33.
Please, ma'am.
Actually, kindly come to page 21.
Yes.
2/3/2021 at 4 p.m. a meeting was held under the chairmanship of the Director of Agriculture and Food Production at 4 p.m. This timing and the dates would be also relevant for the purposes of my submission here.
Yes.
And the tender was assistance in implementation of Mo Bagari Bagicha in AWC held in ground floor boardroom of the Kushi Bhavan.
Correct.
This was a pilot project. Your Lordship finds that the second paragraph, subparagraph, the fifth line. This I'm starting from the third line. This
Yes.
model is to be implemented in 340 AWCs in 3 districts, namely Dhenkanal, Gajpati, and Noapada district. at the cost of 28,000 per AWC on a pilot basis. The total budget provision is first time it was being implemented. Now, a detailed discussion was made and the following decisions were taken for implementation of the program.
Yes.
Then in option next page 2022. The OAIC will be the implementing agency for the program, and WNCD department will place funds with AID and OIC for the purpose. An expert committee will be constituted by OAIC to take decisions on procurement and supply of materials, including seeds, seedlings, etc. Now, this, as it appears, this decision which was taken here, it was decided that the funds would be placed, everything in future knows money, and an expert committee would be constituted to take decisions. And this decision was taken at 4 p.m. Chairmanship of the director. Now your lordship comes to my lord, and this annexure 2, page 90. On 4/3/2024, this was communicated. Formal communication was made to the MD OIC. This was to the Director of Horticulture, FACOM Special Secretary, so and so. Enclosed herewith, please find the minutes of the meeting held under the chairmanship of the Director of Agriculture and Food Production on 2/3/2024 at 4 p.m. on assistance and implementation of Mopakari Bagicha at TWC held in the ground floor of the boardroom at Krushi Bhavan in favor for your information and necessary action.
Same day, yes. Communicated on the same day.
No, on 4th.
On 4th.
To the secretary, to the Director of Horticulture.
Yes, yes. It was on 2nd and it was 4th. 2 days. Within 2 days.
20th, it carries the memo, it's 4th.
Yes, then.
Next page. That your lordship finds the next page. Memo number 8651.
No, I got it. Then
your lordship comes to annexure 3. The tender.
Page
25. I'm sorry, my lord, page 24. Supply of 3-tier vertical mild steel stands. Sealed quotation in conformity with technical specifications, terms and conditions in bid document are invited from registered SSI units who have made state level SLA with OAIC only during 23-24 for supply of 3-tier vertical steel stands. Then, my lord, the next page. This is interesting. Reference 2782 dated 2/3/2024. The top. The EOI expression of interest for procurement of 3-tiered vertical mild steel stand for cultivation of vegetables plants for undermentioned goods from eligible and approved SSI units who have made SLA with OSC in single bid system. Then, my lords, the next one. Bid documents will be available in the latest active EOI of the website number so and so from 10 a.m. dated to 2/3/2024 up to 12 noon on 11/3/2024. If you are
so the meeting was held at 4 p.m.
and the entire decision, so this predates the whole thing, my lords. And then, my lords, even more interesting is this page, the next page, 2026. Empanelment of manufacturers for supply of 3-tier mild steel stand for cultivation of vegetable. If on one hand you are saying, if in one breath you are saying it's a tender for expression of interest for procurement, then on the other hand, in the next breath you are saying that this is only an empanelment of manufacturers. And, my lords, the due date is from 2/3/24 to 11/3/24. This is also, my lords, the signing of the agreement within 7 days. This from 2 to 7, there were it leaves only 7 minutes, three clear days. There were holidays also in between that period. And then, my lords, the next page, page 27. the clause 8, disclaimer clause. The EOI is not an offer by OIC, but an invitation to receive responses from eligible interested firms for empanelment under OIC to install solar irrigation projects for OIC. My lords. From the OIC will impanel limited firms who fulfill the eligibility criteria successfully. No contractual obligation whatsoever shall arise from the process. 1028. Introduction. The three vertical mild steel stand for cultivation of vegetable plants for supplying different Anganwadi kendras for growing fruits and vegetables to meet the requirements for small children at Anganwadi centers in the state. It also enhances the green environment, include the Anganwadi premises. Then the next page, 29. 2B. The empanelment shall remain valid initially for a period of 1 year from the date of publication of empanelment in the list in the OIC website. OIC reserves the right to extend the empanelment duration by another 1 year on the same or mutually agreed terms and conditions subject to satisfactory performance of the empaneled firms. Now, my lords, applicants are required to furnish all relevant documents. Now, my lords, in the counter, they have stated at paragraph at page 3, the counters, they have admitted this position. Somewhere in the middle, the three-tier vertical stand of 340 numbers of Anganwadi centers under development of women and child development government of Orissa for implementation of vertical nutri gardens under Mukhyamantri Sampurna Pushti Yojana. The meeting of the proceeding dated 2/3/2024 at 4 p.m. was released on 4/3/2024. This is what I was submitting before your lordship. Accordingly, expression of interest was published on the same day, that is 2/3, in the corporation official website, an official notice board for SSI units who have made state level agreements with Odisha Agro-Industrial Corporation. It is pertinent to mention that the said meeting, the OIC has been requested to take immediate steps to procure and supply three-tier vertical mild steel stand, which will be supplied at AWC as per suggested specifications in the model code of conduct likely to be imposed shortly. This is the probably the trigger for all these things to have been done. The entire procedure has been subverted here, and in a hurry, they first possibly how this has been worked out is this manner. And even more interesting, we are already writing page 4. Page 4 in the counter. Last first subpara, it is mentioned here that the corporation of 54 numbers of empaneled SSI units having manufacturing units and supplying implements to the farmers through OIC. Limited copy of the empaneled SSI units is annexed herewith. So you already have an empaneled list. You publish a further empaneled list, say publish and call it a tender. And you do it before you even hold the meeting and place the funds. Now, my most, and you give a short window, a very short window of mallards. Effective window is 3 days. And then, mallards, there is no publicity. No, that I have taken a specific pleading in my writ petition at paragraph, mallards. You'll actually find that at paragraph.
No, tell me that what's your grievance? Let us go. I understand everything. That their action in haste has invited many anomalies. And if the meeting was held at 4 p.m. on 2nd of March, and it was communicated to a higher authority on 4th of March, these kind of advertisement inviting a tender published in the website, where the duration for submission has been given from 2nd to 11th.
No wide publicity.
And there is no wide publicity or whatever is done. They use the nomenclature as the tender.
None.
But in fact, they have not finalized the list of the impaneled the contractors or suppliers. Then you say there was already an existing impaneled list. Impaneled list, yet they invited for that. Now everything which they have done, I understood. Now please come to a situation what you have construed the document. Is it a tender or is it is an invitation to make a impaneled suppliers? What do you want?
They are calling it a tender, and I could not participate. I've been declared.
Now what? Are you already an impaneled or intended candidate?
I did not have even the knowledge. And I had the knowledge, my lord, I would have got myself empaneled or applied or done whatever. My lord, I would have had the.
So if they have floated a tender, I do not know what is the date of the tender, either on 2nd or a 4th, as you say, is the second. Second they have floated. In that event, you say that the entire tender has to be scrapped.
My contention for the lordship is this, because the model code of conduct was setting.
That is what this shows that why in hurry.
In a hurry, possibly this has been done in the way that my lord things also operate sometime. That they have found out 2-3 buyers or already, or maybe they had a buyer in mind.
So according to you, that there is you cannot rule out the possibility of a nepotism, favoritism.
So thereafter the process will be completed.
What they did, they selected the impaneled supplier.
Asked him to unofficially submit, and then the papers were prepared later. This can be the only conclusion that can come from this kind of a.
The purchase order has been issued.
That my learned.
Yes, it is issued.
Have you shown it in your counter?
Yes, we have shown it, and they have made those people as parties also. 4, 5, and 6.
They are arranged then, opposite side.
4, 5, and 6.
You have been issued the purchase order?
Yes.
Or whatever. Is a purchase order has to be done.
Purchase order.
Yes.
Supplied the goods. I am simply asking, have you supplied the goods?
No.
What is the time limit within which the supply is to be made? The tender must have been finalized in the month of April. Last date was 11th of March, 2024. Then?
That is from within 20 days from the date of issuance of the purchase order. Within 20 days from the date of issuance of the purchase order, and the purchase order was issued on 14/3/2024 to completion.
14/3. That means you finalize the tender within 3 days.
Unless
Last date for submission
was
11th.
11th.
And 14th you have issued the purchase order. Supply?
Within 20 days from the date of
Has he
purchase order.
supplied it?
He said
He says no.
no.
Then
They have not supplied, my lord.
where is the code of conduct?
What happened, my lord, in between?
Why in haste? So hurry?
They came before this honorable court, and we made a submission that since the model code of conduct has come, so we are not going to implement it right at this stage. That is what was a submission before this honorable court.
No. If the purchase order was already issued, it is only the supply. Code of conduct does not really impede supply. It only says the process you cannot initiate. This has come to an end.
They have taken instruction with regard to whether they have supplied or not, my lord, because I also need to check it up. With the authority.
Order number 3, my lord, they filed an application. Order number 3 dated 3/5/2024 of this services code. Wherein the interim application has been filed by the rate petition with a prayer to direct the opposite parties not to execute the supply order and keep the same in abeyance. That has been granted.
So that has not been granted.
Not been granted.
Yes,
Not been granted.
Despite
Not granted.
Not granted.
Well, that has been filed but not yet granted. Yes.
So there was no fetter on your part to supply. And the time limit was given at 20 days. Why you could not supply? Why you have not taken steps when the time has lapsed?
I will, my lord, the lordship allows me when this matter is coming after my lord last.
It is only in order to ascertain whether the claim has become a stale one or not. If they have not supplied, because what I find, you are representing the agricultural department.
I'm representing the corporation, my lord, the Orissa Agro Industries Corporation.
Whatever. So agro, your I would say the object and the purpose behind this was to secure the particular, the MS steel to help to grow the vegetables and the fruits to be supplied to the children who comes in the Anganwadi centers. The crop is a seasonal one. The fruit bearing trees are the seasonal one. If you could not achieve the purpose, then it becomes a stale now. So it has to go because every action is in haste. You cannot float a tender unless a decision is taken. You cannot give a retrospective date for submission of an application. And then you cannot restrict the said tender into futility. When you wanted to impanel the suppliers, and within 3 days, the order was issued. Till date, no implementation is ensured. What to do?
May I humbly, my lord, please?
Nothing.
May kindly come to page 10, my lord.
Yes.
My lord, in fact, I placed it, but I wanted to, my lord, bring to a lord's notice.
Yes.
Page 10 may kindly be seen of my countermand.
Yes. What?
The meeting on 1/3/2024, my lord, the meeting was convened.
Yes.
That with reference to the subject cited above, it is to intimate that the meeting scheduled to be held on 2/3/2024 for finalization of the implementation of the work under the Book Porkari Bagicha in the Anganwadi Center in the WC department. 2/3, the meeting was convened, my lord. It was finalized in that meeting that this tender to be floated, my lord.
But the tender was floated with a retrospective date.
No, on 2/3 only it was floated.
At 10
The only thing, my lord,
10 a.m.
my lord, only thing is,
meeting is ended at 4 p.m.
meeting was, my lord, it was supposed to be, my lord, because on 1/3 only we have given a notice that 2/3 the meeting will be held, my lord. Accordingly, the
4 p.m. Tender floated prior thereto.
Tender was prepared, my lord, and it was, my lord, uploaded in the website. So it was written only, my lord, it was 10 o'clock, it is open. But I do admit, my lord, because I can't go contrary to whatever is being stated, my lord, in the.
It reminds me of the King's decision in Alice in Wonderland.
But one thing I wanted to bring to lordship's notice: the petitioner himself has never executed any agreement as a SSI unit with the Orissa Agro Industries Corporation. So even if
with somebody he wanted to get himself impaneled,
he cannot, my lord, because if your lordship may kindly see the advertisement
clauses.
No, he cannot, my
You
lord.
say the impanelment and all, everything is to be done.
Yes, it is to be done prior to that particular date. That is also there in the advertisement. I wanted to bring to your lordship's notice. Lordship may kindly come to my lord the advertisement itself, my lord.
Suppose if he has no place.
Place
The purpose and object.
He is a meddlesome interloper, my lord.
Whatever, they entirely frustrated because they have not supplied the goods.
Only
purpose is there.
My lord, lordship may kindly come to page 24.
But that will invite, if they have committed a default as an impaneled supplier, you know what is to be done to such impaneled supplier.
My lord, may kindly for a minute, my lord, page 24. For a minute, my lord, may kindly come to page 24. Page 24 may kindly be seen. For a minute, page 24 may kindly be seen. Sealed quotation in conformity with technical specification, terms and condition in bid document are invited from registered SSI units
who have made SLA with OAIC only during 2023-24 supply of C. He had never made that. He had never executed any agreement. Not a SSI unit was made in agreement, my lord. So he can't participate in the tender match. He was not eligible to participate in the tender. So after the tender process is over, he comes before this honorable court and shows that these are the defects which are there.
There may be an interloper or a medulla, but ultimately the purpose is.
My lord,
The purpose is totally.
my lord, only
is
those
gone.
people.
Now there is no use.
Purchase order has already been issued in favor of them.
There was a stipulation that within 20 days these
They were
supplies
supposed to
be
do it.
made. Why I asked this question was reason. If the supply has already been affected, then we have to see that whether we will. Now the situation is the supply is not being. More than a year has elapsed. What remain? Why the authorities don't show such a stubbornness or inclination towards a particular supplier who is admittedly in default, yet no steps have been taken. You can't keep that purchase order alive.
I've seen, my lord, the other clauses also.
Oh. Then what do you mean? Suppose he has no, he's a the meddler, interloper, the things, whatever. But we can't shut our eyes to the
fact.
Reality of the fact. What we do? God. Sorry, absolutely. What to do there? You have to record that steel killing now. You have not extended the time, nor your supply, nothing.
I have no idea about their supply, my lord. I can't make submission because
He says that
they are saying they have not supplied, my lord. Then
My instruction was not supplied, but if you lordship may allow some time, I'll take some instruction and file counter that.
Yes.
What counter?
My lord, as to why, whether the supply has been made or not, and if not, my lord,
There is no interim order which is operating in the.
About them,
So
I
there
know.
was no difficulty. And he approached the court after that 20 days period expired. The purchase order was issued on 14th of March 2024.
he has approached on 20th March. My lord.
The red court.
He has approached, my lord, on 20th
court.
Yes. 20th March. 20th March. 20th March.
I thought that it is in May.
No, 20th March.
Whatever. There was no interim order. Show us that you have supplied or not.
One more opportunity.
Both of you are.
On Monday, let's make it this matter to Monday. By that date, I will take instruction. Whether they have
Tomorrow, why
supplied.
not tomorrow?
Let's make it this tomorrow, my lord.
Just to take an instruction whether
Yes,
the
yes,
supply
yes.
has been affected or not.
Yes, my lord.
He will say.
Let-
He will
let-
say, I have already supplied.
My lord, I'll take instruction today itself.
Is there another scenario?
Let's make keep this matter tomorrow.
Tomorrow?
No, sir.
There's a third matter.
Yes, sir. Third.
Two matter has already been directed.
Yes, yes.
Yes.
Item 34.
Yeah, please. In matter, you see the petition has been disqualified from the tender, you will see with the conditions which are not have been
This
complied
matter-
with and just.
This matter will seek some time next week because the concerned council is ill. Mr. Bhukta.
Concerned council.
Mr. Bhukta is a CGC. He's with me, but he's been that's why next week again.
Personal ground of a lawyer. Next week.
1 week. 1st of July. 1st of July. Item 35.
In this case, the last occasion, my directed to find a affidavit is a national emblem matter.
What is?
National emblem should be utilized.
Yes.
My lord taking very seriously, and we are also taking very seriously about the utilization because the nation's symbol.
Absolutely.
And we are also, I am thankful to the petitioners, there's many things we have gone through it. Sometimes some mistake has been happened, it's admitted. In that part, the government also taking very serious steps in this regard and issue circular to all the chief secretaries recently. And we will file an affidavit in this regard. Further affidavit, I am seeking about this, what further action they have taken in this regard. My humble submission to my lord is that. In the meanwhile, this similar matter has been dealt with by the Karnataka High Court. Lordship may adopt this same method what they have been, I am supplying to the court. But next date we will file the affidavit. Also, Lordship may examine the same affidavit what verdict has been taken care of by this court. Otherwise, Lordship can add many things in this regard. Well, I am considering that it is a serious issue and the government is very careful in this. Yes, yes.
The emblem is the national flag.
National flag, yes. We have to very cautious about the legal consent. Yes. That's why I am considering that this is many issues they have taken, it should be taken care of. That the government should take care of in this regard and they have taken seriously. That's why the ministry has issued a circular to all the chief secretaries. And to further any irregularities or anything, take serious steps in this regard. That circular is there and healthy.
Your Lordship, admittedly they are taking actions, but the actions they are taking, it's right, but it is totally wrong or partly
However, what he says is that there has been certain lapses, is they have noticed. And they also say that the government is taking a serious note of those lapses. In the meantime, the Karnataka High Court has already issued the directions that it has to be done. He wanted to place it. Suppose if we adopt it, then we can adopt that. Or if we want to add something more into it, we will definitely add something more into it. After hearing you, I understand you are a alone person. There is nobody to support you from behind. The name suggests that.
Yes.
He is the alone trust.
Alone trust.
So he is a single person. He wanted to bring it by way of an affidavit, whatever it was. Also, you can find that affidavit.
Let's see, keep it after 10 days. In this. 10 days. After.
Twice. 22.
22nd
22nd July.
Yes.
Item 36.
May I please, my lord? There's two orders of this on before. First one was when the notice was issued on 7th of March 2025. This Honorable Court directed the Union of India as well as the state government to file counter.
Time may be granted for filing counter.
But it is the second extension of first extension.
Yes, second extension.
Second measure.
My view or the principle is that it's the second extension, then put on terms.
That's last opportunity, my lord.
First extension, I grant, subject to my brother agreeing with me. Second extension, all along, put on terms.
Let's say receive the paradise comments, my lord.
Whatever, put on terms.
Just small request, my lord.
That is my brother, I am not convinced. That's the procedure I followed throughout.
And this is last
of 2 months time was.
Yes, my lord.
It's not 15 days or 1 month. 2 months. So they can sleep over for 2 months and even at the last moment the paradise comments could happen. I agree to
Imposition of cost.
Let's last opportunity.
and the authorities to be.
You grant you costs.
Cost not at this stage itself. Cost of this.
It will not go to them, but will go to some noble cause, which is under the directive principles of the self. Yes,
Thank you. Just last opportunity, man. That's
have to pay. 1,000 gold bars. Yes, means 17,000 rupees.
as in a shipping.
We will extend the time, but 17,000 rupees cost.
And it's as in a shipping.
For providing the clean hygiene water in the juvenile homes. Any homes which do not have that for water purifier, they'll have to buy a water purifier for this amount. Yes.
This central government is passing an order under NHR 8. And this regional authority observe that. Just I am reading my lord. The authority empowered under section 30 of MMDR Act has no power to amend any
You are
order.
also directed to file counterfeits, right?
This is not a matter of direction.
Yes,
Regional authority
you are-
pass the order. You can compel us to file the order.
Hey,
Yes,
no,
regional authority pass the
court
order.
has signed.
The SLSA. SLSA will utilize that particular amount for providing that the water purifier in any of the juvenile homes where it is not. Yes. An opportunity, the order was, the direction was passed upon the state opposite party to file their counter affidavit.
As well as the union government matter.
See, Union government is not going to file with the regional authority.
He is not agreeing for extension, which was extended on 21st of April 2025. Despite the time having extended for filing the counter affidavit, no counter affidavit is filed from the state opposite parties. However, this Das appearing for the state please for further extension of time to file counter affidavit. The learned PSG has conveyed the stand of the union opposite parties that they do not intend to file the counter affidavit. Since the second extension is sought for filing this counter affidavit, we feel that the state opposite party should be put on terms, as they cannot continue to protract the litigations for all time to come. Since the right to file a counter affidavit is one of the valuable rights, we extend the time for filing the counter affidavit by 2 weeks from the 2 weeks or 3 weeks.
2 weeks, man.
Subject to the deposit of a sum of rupees 17,000 with the state legal services authorities by Monday. I gave that date. Monday, 30th.
17. My love, 17 or 70?
17,000.
17.
17.
17,000.
1,000 gold bars, I said so.
Yes, ma'am.
17,000. By Monday. The state legal, the SLSA shall utilize that amount for providing the water purifier in any of the juvenile home within that state run, a state or NGO run. This is the matter after 2 weeks. Yes.
22nd. 22nd. 22nd July.
It's for the next.
Item 37.
Order to continue.
Interim order passed earlier. They'll continue till the next.
But
Item 37.
A little digression.
That requires also for our help. So, well, here, the petitioners, in fact, the grievance is that they claim the class within the class.
Oh,
Yes.
it is a classification of a class within the homogeneous class.
Yes. So
That's permissible, provided on
provided,
a intelligible differential.
Yes.
That has to be.
and rational basis also, reasonable. So here, the petitioners, they are all the residents of Sukinna mining area, which is very rich in that mining of the chromite ore. But from their forefathers, they have lost their houses, and lands have become uncultivable, all these things. And while there was few operations there, the extraction, that time they have adopted that for transportation of the minerals. And they live on that, they having their own trucks. The trucks they have given them. Earlier, well, there was a lot of disturbances was created, and the people, well, those were not the so much of having the muscle power or on the disciplined manner they wanted to do that. All disturbances was created. Earlier, their association had come before this Honorable Court.
Yes.
And it was directed that will be fast load basis.
Correct.
And the law and order situation will be also maintained by the local police and administration. That went up. So subsequently, but that was also disturbed. And they sometimes they did not get the chance of the loading. So that is why they demanded that please make a policy, make a modalities so that at least we can be given 50% of modalities, 50% of the loading for transportation so that we can earn our livelihood. So in this regard, a meeting was held. And in the meeting that was presided by the Transport Commissioner, who is the opposite part number 5, and 6 is the Transport Secretary. In that meeting,
it was discussed. The association also supported this petitioners, those are the owners of the trucks were present there. And it was said that in that proceeding.
These owners of the trucks are actually the land losers.
Land losers, and they, because Lordship kindly speculate that positions, that while the mining operation is going on, dust are coming, lot of trucks are coming. So in fact, they lose their livelihood for whole time for the agricultural land, all these things. So that is why they have adopted this method of transportation of the minerals by loading process. And a lot of people are from the outside are also coming, and your Lordship can also, the number of trucks, those who have the transporters, they must have the dominating power, they can utilize that. So here in this regard, it was addressed on this point by the Transport Commissioner in the meeting, and it was decided it will be moved to the higher authority to take a decision. And thereafter, it has not proceeded. So the counter though has been filed by the OP number 1 to 4. They have repeated the same thing what we have said in the writ petition. So, but 5 and 6, they have not replied nor addressed our point.
Who are 5 and 6?
5 and 6, the Transport Commissioner who presided over the meeting.
But there was the resolution of taken in the meeting was forwarded to a higher official.
Had to be forwarded to higher authority.
Forwarded it or the
Not forwarded, we don't know anything. We are in cloud.
In the counter they have to disclose that
No, no.
forwarded.
The 5 and 6 have not filed the counter.
Mr. Prabhakar, they have standing counsel for transport. Prabhakar.
That
You are appearing for transport, no? Standing counsel for transport is.
but transport secretary can he can appear for this transport secretary of the government. He can appear. So it is only.
When Mr. Prabhakar, when a standing counsel, he usually appears.
He appears, Lord. So far the motor vehicle matters are there. But so far this matter relating to modalities, policy, whatever the government has to take a decision. In that regard, your Lordship kindly see the proceeding. Annex 8, page 68.
So this resolution is actually kept in a cold box.
Right. That is what. I've specifically avoided in the writ petition.
This is a cold storage.
Yes, it has not been
Yes,
addressed.
what you say, why, in the resolution, either you take a conscious decision, yes or no.
If I may refer to page number 17 of my counter.
Have you taken a decision on the basis of the resolution, whether the resolution, copy of the resolution was forwarded to you?
In the meeting, in the said meeting, everything was discussed and various points were pointed out for effectively carrying out the orders of this honorable court, my lords. If I may refer to
Kindly see page 70. 70 you kindly see.
So what was the order of this court?
First come, first basis should be effectively implemented. That was the order of.
First come, first basis.
Yes, my lords.
So they are the local people, so they are the
My lord, kindly go through that part of the what I submitted before lordship, page 70, page 70.
And you should read that more.
As far as the grievance of inhabitants of Sukinda mines area is concerned, the same will be apprised to the higher quarters for appropriate action. That has remained in the court storage.
So have you apprised?
Well, it's gone through the order of this of the Honorable High Court of Orissa. If I may read this portion, my lords.
That I am submitting.
Difficulty is a first come, first basis.
Yes, my lords. The principle of first come, first basis will be applicable in all category of
That is the
mineral
whole
transactions.
difficulty.
Yes, my lord, that's.
That really brings up the Pandora box for a nepotism and availability. Who will monitor that who has come first and who has come last?
And that the WhatsApp group has been created.
What is the functioning of the WhatsApp group?
Where
In the mining area where the ores are extracted or the minerals are extracted, they are stacked in a particular place. You do not know that where it is stacked and who has come to upload it and then offloading some other place.
Well, it's all the mining lessees were instructed to display their loading requisition and target, my lords. My lords, if I may just refer to this document, my lords, once. Annexure B.
Paragraph
report page-
15 Milord specifically about, not reply.
Since it has to be done. If there are local transporters, they should also be ensured that at least a one offloading or a one uploading, or a two uploading or a two uploading, they have to be ensured rationally among all.
That's right. I'll take further.
First come first basis is a very difficult,
My lords, that's what has.
very difficult to ensure.
Yes, my lords. That was the direction given by this honorable court.
So
my lords.
we can supplement the directions, there is no difficulty.
And
We
accordingly,
can supplement.
and accordingly, this proceeding was taken out.
That was a direction passed in this matter or
Different matter, my lords.
in a different matter by a single bench or a division bench?
That's division rules, my lords.
Division bench that was decided on the basis of the collector decision taken in that matter, then it was not implemented. That is why to support the law and order situation and to do that. So not that the Honorable High Court has directly.
Page 69, last two paragraphs.
Yes, my lords.
Yes.
Page 69.
Yes.
Yes, my lords. Also, page 16 of the counter, which talks about effectively.
At the time of acquisition of the entire area for the mining purposes, you have lost your land.
Yes, that time.
Correct.
Forefathers.
Was there any scheme for providing any employment alternative settlement? Any kind of these things were there?
That I cannot say. But specifically my amendments in para 15, it is not addressed because obviously they could not have stated this because the counter is not by the OP number 5 and 6.
Decision, the secretary can take a decision what to do. If he says,
Yes,
I'm not agree, communicate.
It's only, my lords, once, if I may refer to page number 17, my lords, and I may read the relevant portion, and it should be by page 17 of my counter, my lords.
What?
Wherein a decision has been taken, my lords.
Why?
Yeah, by the
That is the
additional
thing
district.
which is conducted by a transport
Commissioner.
And additional district magistrate Kalinganagar, my lords.
Correct.
Yes,
But he says that ultimately this decision has to be communicated to a higher official.
My learned friend is reading from the district ADM presided the meeting. But here subsequently the transport commissioner that kindly see that the annexure.
So that's a subsequent one.
Yes, my lords. I'll take instruction from the transport commissioner. Here the mind. My lords, I'll take instruction.
We
from
are
the-
directing you to communicate this resolution and take a conscious decision and inform the court that what is done. We are keeping this matter pending, but inform.
My lords, here transport commissioner, my lords, notice as to, my lords. With respect to transport commissioner, because annexure.
Not just because you appear from the transport commissioner and the government. That is the government.
You are representing the secretary of the Department of Transport.
Yes, my lords.
Who is the highest authority? Principal secretary in the transport department is the highest authority now, above the commissioner.
Yes.
Take a decision. We are not saying that what decision you should take.
Your Lordship may pass direction on the transport secretary to pilot affidavit. So the matter. So that can be sorted out, my lord.
That will be helpful to the fraternity to some extent, unnecessarily much. Okay, instance with racing, the reverse. The allotment of the trucks for the purpose of loading and offloading of the ores and of minerals extracted at a Sukunda, what is this?
Sukinda mining lease.
Sukunda mining lease.
Mining lease area.
As they lose, as they lost their homes and the land. Full stop. There has been discrepancies noticed by the transport department on the basis of the grievance raised by the officers who are primarily the land users, and a meeting was held. Entered into a resolution which was agreed to be forwarded to a higher official for taking a conscience thereupon. It appears that the grievance is not of a recent origin, but a recurring one. Which can be first off, the corroboration can be seen when the counsel for the state submits that in one of the litigations before this court, an order was passed that the allotment of the truck should be strictly made on a first come first basis. Subsequent thereto, the grievances were flagged, which need the conscious decision to be taken thereupon. Stop. We therefore direct the principal secretary, the Department of Transport or Transport Department of the Government of Israel or Government of Orissa.
Department of Transport. Government of Odisha, Department of Transport.
I have said Principal Secretary to Government of Odisha.
The Department of Commerce and
Transport. Department of Commerce and
take a concert decision on the basis of the resolution annexed to the writ petition at page 17.
68 to 70.
68 to 70.
Annexure 8.
And communicate the same on the next date of the listing. Stop. List the matter after 3 months. Let him take a decision.
My lord, in the proceeding, it has already been stipulated who has to do what, who has to register the vehicle, who has to IH and others. They have.
Let him take a decision subsequently.
Yes, ma'am.
Yes.
Item 38.
The work has not been awarded in his favor and only in verbally at the time of opening of the price bid, he has been told that he will not be giving the work since he has not quoted the rate as per the workable rate. And your lordship may see the tender call notice.
Proceeding, I'm appearing for an interview.
Intervention of you.
I'm appearing for the interview on the last occasion our IA was allowed. We were inducted, we had received a copy of the rejoinder and everything. We need some time to file a reply.
On that day, your lordship.
Order has not been issued or issued.
Not been issued.
Come on Monday.
Lordship.
If he's adjudged as a L1, then why on that ground that the price is
30 rupee difference
is a unworkable or unreasonable price? That is up to him. He may suffer a loss. You may incur a loss. It is why the tender processes are introduced in this kind of a things is to have a competitive rate.
And he is working now
What
also.
is a commercial wisdom? One may decide to suffer a loss. Let him suffer a loss. His only thing is the quality. The quantity has to be maintained by him.
It is a transport contract.
Whatever. The quality means the quality of service.
Yes.
And quantity means the quantity to be transported.
If I have own trucks, then I can transport it lesser rate, madam.
We have already filed the counter. On normal rule, committee decide what is the workable
price.
Whatever is the workable price, the committee decides, and on basis of the price.
Then what is the purpose of floating a tender? You could have said that this is the workable price. The committee has already decided. Whoever can render services, transport services at this price, come.
But
No such stipulation. There is no question of any floating of the tender.
No such stipulation is there also not.
I understand. That cannot be. Never. This is never done. This is the first instance I have come across. And that the lowest bidder is denied because the price is not a workable one. You are benefited, sir. The state's exchequer is not burdened. No, sir. I have not come across this kind of a step. Monday he come.
He is continuing my.
You are asking for a time, but we are giving you Monday, but we have to.
Copy already on that day I have given. I have undertaken. Entry order may be explained. Entry order is there. Your lordship is
already there.
Yes.
On the prayer of the intervenor, let this matter be listed on Monday. There is a 30th. The entry order shall continue.
With your lordship, may I be allowed to renew my prayer? Item 40, I had mentioned in the morning. I have been served with the counter affidavits yesterday. I would require 2 weeks time to file a rejoinder. The state is there.
Lord, I am appearing for OP number 7.
Item 40.
For one,
Lord, I appear for OP number 7 on VC.
10 days.
Item 48 tomorrow will be taken.